trying to force policymakers to react. Enough of treating nature like a toilet. We are digging our own graves. We are in the light of our lives, in the fight of our lives, and we are losing. We are on a highway to climate hell with our foot on the accelerator. There is still hope, of course. We must accept finite disappointment, but never lose infinite hope, as Martin Luther King said. It is crucial that not only policymakers, but also legal practitioners, academics, students, and civil society at large are involved in these discussions, as everyone has a role to play in this matter. Well, this event is being streamed live on the Universidad Carlos III YouTube channel and also recorded. We appreciate your consent for doing so. So welcome and many thanks. And we are very privileged to having here, as I have already said, Professor David Ramos, the co-director of the Master in International Advocacy, Professor Robinson, the current president of ISEL, Mr. John Scanlon, the elect president of ISEL, and Professor Joaquin Alcaide, who is a co-principal investigator of Pax Natura project and professor of international law in University of Seville. So first, I should give the floor to David Ramos.
Thank you very much, Professor Abad. Can you hear me well? Let's see if I can get this one. Okay. It was my plan to be very brief because my idea was to just give everyone a warm welcome and thank Montse for the opportunity to be with the experts, the real experts, today here. But since the Masters is supplying a large part of the audience for today's symposium, I think I'd say something very brief to those of you who are attending today. The concerns about environmental matters, human rights matters, trade law, investment law, and humanitarian law are not just the domain of specialists. And this is a message that we want to resonate loud and clear for those of you who are specializing in other fields. What we do in this master is we have the two specialties, dispute resolution and transactional. So let me paint the following picture to you, okay? You are advising an international transaction for the acquisition of a specific firm that somehow has an industrial, is an industrial supplier. You are double teaming because you have the M&A team and you have the dispute resolution team that has to advise on exposure to litigation risk. Now let's imagine that this firm is a major manufacturer of batteries for electric vehicles and solar panels. So the first question will be, does this has a revenue generating capacity or not? But then if you descend into the details, you see that some of these panels and batteries are assembled in certain regions of China, and one of the suppliers of these materials has been blacklisted under the US Uyghur Forced Labor Protection Act. How exposed you are to liability. And then one of the suppliers of this firm, way down the value chain, has applied for a permission to the International Seabed Authority for commercial exploration of rare minerals in the Clarion-Clipperton zone in the Pacific. Is an authorization by the ISA sufficient for that firm not to be exposed to subsequent potential sanctions or litigation risk? You are M&A lawyers, you are dispute resolution lawyers, and you have absolutely no clue of what people are talking to you about. And yet, this could make or break your very specific deal. So even though we have started with a very high purpose, since I'm a very practical person, I like also to convey to you the impression that it is impossible nowadays to be a good M&A lawyer or to be a good dispute resolution lawyer without properly understanding environmental law, human rights law, humanitarian law, trade law implications. So in that sense, it is a privilege, Montse, that the one that you're bringing to us, you and your colleagues, and I encourage you to listen because this is what us, the practical lawyers, should do in this scenario. Thank you.
Thank you.
Well, buenas tardes a todos. It's a great pleasure to be with you in this room. I've been in this room several times on TV, on the screen. It's my first time in person, so it's a marvelous room, and the Universidad de Charles Terceros de Madrid has been a wonderful host for a number of ISIL meetings here. We're very proud and pleased to be associated with this university. The challenge that we face right now is that environmental law and the problems of the environment are not distant. They are with each one of us. They are with each one of you for the rest of your lives. As Secretary General Guterres has said in the words that Professor Abad has quoted, we are in a serious crisis of the economy, a serious crisis of the culture, a serious crisis of the science. It's never been quite this way for humanity before. And so we have to rise to this occasion and use the best that humanity has to solve this problem. And your wonderful master's program, the university's program, all of us in ISIL around the world cooperating with different experts in environmental law are committed to solving this problem. It can be solved. We have the technological means to prevent the degradation further of the environment. We have the alternative development models for sustainability. So why aren't we following this path? Well, the transformative effect of law is that law can help us change to follow that path. But it won't happen because a professor says so. It won't happen because a judge says so. It will happen because each of you, as specialists in this field or as generalists from outside this field, each of us has to make it happen. And we can, and we shall, because that's what humans have had to do since the very beginning of our species. So today we're going to try to explore the possibilities and some of the problems. We'll talk candidly about why things don't happen, and then why we have to imagine the workaround. If you reach a roadblock, do you just sit there and wait? Or do you find the way around the problem to a solution? So we're very honored to be here. I commend the university for helping put together and sponsoring all the research that's going on with Pax Natura, all the research that I would say Spain is taking the lead on internationally and promoting. So for the next couple of days, we will enjoy sharing your wisdom with us and seeing how synergy can be built around these ideas. Muchas gracias.
Thank you.
Oh, I can use this one. That's okay. Yep. Good afternoon, all. Lovely to see so many young people in the audience. I don't know if you can see them online or not, but we have a great view of a whole vast array of young people in the audience. And I didn't know what I was going to say in my opening remarks, but listening to Nick, I thought what I'd raise is an issue that is always raised with me when I speak with young people, whether they're lawyers or not lawyers, and that is with all these multiple crises that Nick's just talked about, that are all converging, are you an optimist or are you a pessimist? Now, my answer is twofold. Firstly, it depends what mood you get me in. Tony got us in a good mood, so I feel like a bit of an optimist. Other times, I feel like a real pessimist. But ultimately, it doesn't matter whether I'm optimistic or pessimistic, because if I'm pessimistic and I sit in my room and get depressed, there's one thing you can be sure of: nothing is going to change. What we should do is just, within your own sphere of influence, do whatever you can to influence people around you, influence activities around you. And you know what? If enough of us do that often enough, we may surprise ourselves. We may actually turn this around. And with all of this crises and everything we hear about, you know what that also does? That opens up opportunities for creativity, for innovation. I think now is the most exciting time to be in environmental law that there ever has been. Why? Because there are so many things to be solved, but you can apply yourselves to these, be creative, be innovative, and if enough of us do that, we will turn it around. So great to be here. Thank you to the university. Thanks to you, Monse. Great program. Lovely to see you all here and looking forward to the proceedings today. Thank you.
Thank you. And finally, Professor Akinokaida.
Thank you very much. Just a few words to thanks and congratulate once more to Professor Montserrat Abad for all the invisible work behind this symposium, the audit that will be held after tomorrow, and the other ISEL meetings and events. Many thanks to Professor Robinson and Mr. Skeldon for the leadership of ISEL over the past years and into the immediate future. And thank you to Universidad Carlos III de Madrid and ISEL and my other colleagues from the Paz Natura Research Project for the organization of this symposium. Thanks to the academic coordinators, Professor Robinson and Abad, the academic secretariat, Mr. Romero, the partners and the supporting universities. And of course, thank you very much also to all the participants, chairs, presenters, discussants, which are a guarantee of its success, and the audience. I wish all us buen trabajo, good work. Thank you very much.
Thank you. So the symposium is formally opened. Let's move to the first panel. Thank you.
Bravo.
Bravo.
Ben, you want to join us up here? We're going to the first panel. Do you want to sit up on the podium? I think it's best.
Econ, here. This is for you. And now,
Where's Chen? Chen. We need one more seat.
Yeah. We have to move down. So,
That's all right.
okay,
Just sit in front of this.
okay then. We don't move.
I think we're good. Okay, that's good. McKinley is going to be online. So yeah, she's online now. All right, very good. I think we've got ourselves pretty well organised. Some of our speakers are going to be joining us online, and others are here in person. My name's John Scanlon. I'm the incoming Executive President of ISEL. It's a great pleasure to be here, and I just made a few opening remarks. We have an extraordinary first panel. The title is Europe, North America and South America, Asia and Africa. But basically what we're going to do is we're going to go right across the globe, multiple regions, deep dive into particular states, Brazil, USA, have a particular look at issues to do with the EU, and we're going to cover a broad array of subjects, nature restoration, environmental defenders, the notion of the ecological civilization, human rights issues, and very specific developments, as I said, in particular countries. Now, we have a very distinguished lineup of speakers, both here in person and online. They are all very eminent in their fields, and I'm not going to read out their CVs because they would not be given a slot on this panel if they didn't know what they're talking about. So I'm just going to introduce the speakers by name and title and topic, and you can learn more about them online if you'd like to. Now, I don't want to spend any more time introducing the subject because we really want to hear from our experts. And we're first going to hear from Professor Eckhard Rembinder. He's an emeritus professor with the Goethe University in Frankfurt in Germany. He's a member of the ICEL Board of Governors, and he will be talking to us about EU regulation on the restoration of nature. Over to you, Eckhard.
Okay. Inspired by the European Green Deal of 2019, the EU has recently adopted a number of ambitious new or amended legislative texts on the environment, such as the new climate law, the new environmental crime directive, the corporate sustainability due diligence directive. However, in my view, the most interesting new law is the EU regulation on nature restoration, also called Nature Restoration Law. That has to do with the, well, I would say with the official name of sources of law under EU law, and the term law is not known there. Since this regulation is a landmark piece of legislation, I will focus on it. The new regulation, which is a key element of the EU biodiversity strategy of 2020, aims to tackle the dual challenge of biodiversity loss and climate warming in the EU. The emphasis is laid on biodiversity, but climate change is encompassed insofar as the function of nature as sink for greenhouse gases and its ability to serve for adaptation are concerned. The general objective of the regulation is to serve, to contribute to the long-term and sustained recovery of biodiverse and resilient ecosystems, that is the exact citation, to the long-term and sustained recovery of biodiverse and resilient ecosystems across the member states and its land and sea areas through the restoration of ecosystems that are already degraded. The new regulation supplements the existing sketchy system of nature regulation in the EU by adding an overarching framework. It combines a general long-term objective with tiered binding restoration targets for specific habitats and species. These areas are land, coastal, freshwater, marine ecosystems, as well as agricultural, forest, and even urban ecosystems. With respect to terrestrial, coastal, and freshwater ecosystems, such as grasslands, wetlands, rivers, and lakes, regulation requires the member states to put in place restoration measures by 2030 on at least 30% of the total area of habitats contained in a list the EU has on all the habitat types that are not in good condition. This is equivalent to about 20% of the area of all listed habitat types. Further restoration tiers follow by 2040 and 2050. In addition, there are special non-tiered restoration obligations applicable to habitats, protected habitats, and habitats of protected species. As regards the contents of the restoration obligation, the regulation mandates the member state to take restoration measures that are necessary to improve to good conditions the relevant areas. This is to a certain extent specified by a requirement of continuous improvement. However, the regulation does not contain result-oriented obligations in the strict sense. Member states are in principle free to select the relevant areas for the purpose of devising restoration measures, but in the first restoration period, they may give priority to Natura 2000 sites, which of course facilitates restoration and is liable to impose less onerous burdens on farmers. Against the backdrop of adverse impact of modern agriculture on the state of biodiversity, the regulation provides restoration measures for enhancing biodiversity in agricultural ecosystems in addition to the general obligations. And so these measures shall aim to increase national trends towards achieving a favorable state of the agricultural environment, the number of birds and pollinator populations based on certain indicators. A very controversial issue has been the concept of restoring organic soils that constitute drained peatland by rewetting. In Spanish, I think it's rehumectación, rewetting, rehumectación. And that mainly serves as a contribution to reduce greenhouse gases or net emissions. But rewetting may impair agricultural and other uses and make peat extractions even impossible. Even though the regulation requires member states to take restoration measures in this respect, this is not mirrored by obligations for farmers and other landowners to rewet their land, which of course means that success of the rewetting policy will depend on availability of non-agricultural land and regarding agriculture on either incentives or more ambitious national obligations. The regulation contains detailed provisions on the contents of the restoration plans and the applicable procedure, and there is some sort of watchdog function vested in the Commission. The Commission may check the draft of the restoration plans and make remarks on it. But the only requirement is that the member state shall take account of these remarks, which of course falls short of a strict adjustment duty. The regulation tries to strike a balance between the interest in enhancing biodiversity and the interest of farmers and other landowners to use their land without far-reaching restrictions. This is reflected by the essentially procedural approach of the regulation and the rather weak rules concerning wetting of peatlands. Moreover, there is a clear contradiction between the nature restoration concept set out in the regulation and the recent deregulation of ecological requirements for receiving income aids in the framework of the Common Agricultural Policy, especially the recent renouncement to set aside crop rotation and protection of grassland until 2028. In addition, in keeping with the recent EU speeding up legislation, the regulation grants certain facilities for the generation, transport, and storage of renewable energy and other so-called environmentally friendly energy at the expense of nature restoration. So one can say that despite these flaws, the new regulation on nature restoration, with its holistic restoration concept, is a landmark piece of legislation that seems to be in this form unique in the world and constitutes a responsible implementation of the Biodiversity Convention. The effectiveness of its regulatory approach needs to be tested in the future practice. And let's hope that it will not just remain to be a piece of legislation on paper. Only experience can teach us about the possible need to improve the regulation in one respect or the other. Thank you for your attention.
Thank you, Eckhard. Fascinating and a very adventurous piece of legislation. I suggest it's beyond biodiversity, it's also desertification and climate, probably the 3 Rio conventions that are captured in this one. We're going to now turn to Professor Nick Robinson. You've just heard him give his remarks, so I don't need to reintroduce you to him. But he is going to be talking about the US Supreme Court rulings restricting federal government's authority to protect the environment. Over to you, Nick.
Well, thank you very much, John. We've just heard a very optimistic report from the European Union. I'll give you a slightly pessimistic report from North America. But that doesn't mean we don't fight the fight still. We have to do our progressive reforms. In the 1970s, when I was more or less the age of many of you in this room, we thought environmental law was a brand new field. It would grow quickly, it would expand, and we would always have a trajectory toward care for the planet and nature. And that happened for a time. But then forces that found the economic pressure grew more upset. You couldn't continue to extract nature and natural resources without impediments, and therefore you had less profits in the short term. And so a pendulum swung back the other way, and I'm here to describe you where the Supreme Court of the United States has ended up. It's not a happy story, but it's a story that will cause us to continue to litigate and try to change what the court is doing. So in the 1970s, I'll mention 4 areas. One is the National Environmental Policy Act and Environmental Impact Assessment, which is a global obligation under international customary law. You must do environmental impact assessment. Second, talk about the waters. How are wetlands or peatlands related to navigable waters? Third, whether we can rely on the best environmental science to fill in the gaps when the Parliament or our Congress has adopted a law but hasn't figured out quite everything. And then fourth, what's next? Where do we go from there? So in 1969, the United States Congress made a big compromise between people who were against building highways and tearing down cities and those who wanted reforms. And they adopted the National Environmental Policy Act, which for the first time required preparing an environmental impact assessment before you took action as a government obligation. It's now in the laws of the state of New York, for instance, at the state level. The EU has its environmental directive. It's all over the world. We thought that was a great reform, but then the Supreme Court began to narrow how you could do an environmental impact assessment. In a case called Vermont Yankee versus the Natural Resources Defense Council in 1978, 8 years after we adopted NEPA, the court said, well, you must do an environmental impact statement, you must make the assessment, but the administrator doesn't have to follow the results. The administrator can still do whatever they want as long as it's within their lawful authority to act. So it took away the sanction to stop degradation if you identified it. Then in 1989, in a case called Public Citizens versus the Department of Justice, the court said, well, we're not even sure you have to look at all the impacts because there must be what is called a close causal connection between your act and what might result from your act. You have to have a direct link. You can't study the unknown and find the link. So it was like an adaptation of tort law or our public delict law, coming up with a causal connection. So this began to weaken NEPA, and the court has continued to find ways to weaken the legislation. Secondly, we have in our Constitution a federal system in which the states regulate many areas, and the Congress and the federal government regulate the others. One of them is interstate transportation and interstate waterways. So when a river or a coastal area goes between states, the federal government regulates it. In a case called Rapanos versus the United States in 2006, the court decided to reinterpret what is a federal water, what is a water of the United States, because the federal authorities had decided that wetlands were, even though they're not connected to a river, are in fact hydrologically connected through the aquifer, through the underground flow of water. And that was a good enough link to regulate the protection of wetlands at the federal level. The court said, no, no, no. We're going to reinterpret water to mean only water, and only water flowing in a river or in an interstate lake. So the fact that water goes underground, they didn't also say goes through the hydrologic cycle into the atmosphere, they said that doesn't count. So you must have an absolute link. So they invalidated much of the regulation of freshwater wetlands around the United States. And only the states can regulate those wetlands. I'm fortunate in my own state, as a young person your age, I wrote the law to protect our wetlands, which is a very strict law, and it still has been upheld in the courts. So in New York, we protect our wetlands, but in Alaska, the wetlands, Texas, the wetlands don't have protection now, because only the federal government protected it. Perhaps the most significant change was a decision that is called Chevron versus the Natural Resources Defense Council in 1984, in which the Supreme Court quite progressively said, when legislation describes an environmental problem, we can't expect it to understand all aspects of the problem. So the administrative agency can use the best science. We want to know what is science telling us about the problem, and then they can come up with a regulation or an implementation of the federal regulations, federal statutes, which protect nature. Supreme Court in 2004, this last June 20th, decided that that would be rejected. And they said in a case called Loper Bright Enterprises versus Raimondo, a 6-3 decision by the judges in the court, who I would say are ecologically illiterate judges. They don't understand ecology. They overturned the Chevron rule, and it's worth just quoting a little bit from one of the commentaries that comes out. The Supreme Court previously had presumed that Congress, when it left ambiguity in a statute, meant for the implementation by an agency to have that ambiguity resolved, so the science would fill in the gaps. We're learning something new about science every day. How many microplastics are in you and me? We've had to absorb them, and they're in the atmosphere, in the deepest ocean trenches and on the land. Now, that's not something that we regulate as a pollutant, but if it is a pollutant and we define it that way, then we can begin to regulate the flow of plastics. Supreme Court says no. The presumption is that if previously it was where Congress left a gap like that, Congress wanted the agency, the Environmental Protection Agency, to fill the gap. But in the Loper decision, which came out of a fishing exercise, actually, the court concluded that, no, if there's a gap, agencies are not legislatures. Only the legislature can make it. If they've left a gap, the legislature must fill the gap, not the administrative agency. The court, in a very bizarre expression, said that in executing their traditional duty, it is the courts that give due respect to the executive branch for interpretations, but in this case, judges are not scientists, agency administrators are not scientists, therefore the court will reject actions by an agency to fill those gaps and require that Congress be convened again to define the gap. Now, the Congress is not made up of scientists either. So how do you deal with expertise in that situation? The judge basically said in the Supreme Court, only judges know how to interpret a statute, not bureaucrats. But this is a hubris of great consequence, because now all federal agencies must wait until Congress clarifies the law when they reach a gap. And if they try to fill the gap, it could very well be that the courts overturn that legislation. So this puts much of our laws at risk. And the court has gone on to suggest there's even a worse scenario. Our federal laws are based on a part of the federal Constitution that allows Congress to regulate commerce among the various states. And the court at least 3 of the judges have been saying commerce means buying and selling things. It does not mean regulating the market. Therefore, we don't want you to regulate the market for environmental issues. We want the Commerce Clause not to be used as a basis for the Clean Air Act or the Clean Water Act. We will leave that up to the states to do. So this has put at risk most of the federal environmental laws. Where do we go from there? It sounds like we've now removed judicially the basis for federal environmental law in the United States. Well, when this happened once before, when Franklin Delano Roosevelt was the president and we had the Great Depression, an economic crisis for the world, the court was refusing his reforms. And he said, well, we'll ask Congress to amend the number of judges that are allowed to sit on the Supreme Court, and we will then appoint judges to overturn the judges who are so negative. The judges at that time backed down. They didn't want that to happen, so they began approving his legislation. So this can happen again. Depending on the election, if the Democrats win, they can amend not the Constitution, they can by statute increase the number of judges on the Supreme Court, and then the new president, Kamala Harris, would appoint judges to overturn these judges who are against environmental law. That depends on, of course, the election now or in 4 years from now. The other thing we could do is amend the Constitution, but this takes many years and is not very effective because you, meanwhile, are not improving the environment. The third is interesting, and that is that the federal government is a limited government. The states have the sovereignty. They only gave up certain rights to the federal government. So a state like California or New York can begin to have very strong regulation. In fact, California likes to copy the European Union and get good ideas from Europe. So we could begin seeing states that are progressive following the pattern of Europe and states that are regressive doing nothing. And then the final question is human rights. Human rights have evolved and changed. Much of what the Supreme Court is doing is contrary to environmental human rights. And since human rights are universal, and other nations are going to be adversely affected by the failure of the United States federal government to protect the environment, states could insist on a new treaty with the United States, a new pact for the environment. And under the US Constitution, the treaties are considered the supreme law. So if a treaty is agreed and approved by the Senate, then the objections have to be put aside. So Europe could, in fact, or the rest of the world, insist that the United States not take this regressive pattern and based on environmental norms move forward. But for now, we are in violation of the principle of regression. We are moving in our judicial system backward, and it's one of these moments where we all have to rise to the occasion and fight for the principles. Thank you very much.
Sounds very familiar with what is happening in Mexico today.
Sí,
¿no?
claro.
Just exactly.
Okay. I'll just thank Nick and then I'll come to the. Thank you very much, Nick. It's very interesting that perhaps people involved in environment protection in the US are going to start focusing more attention at the state rather than federal level. But I don't know where this ends up with the court, because as the composition of the Congress changes, you keep stacking the Supreme Court to get the numbers on your side. So it sounds like an interesting proposition, that one. I don't know where it ends. We've got our next speaker online. Unfortunately, he's got problems with his camera, but we will be able to hear him. We have our dear friend, Justice Antonio Herman Benjamin. He's the president of the Global Judicial Institute on the Environment. He's chair emeritus of the IUCN World Commission on Environmental Law, meaning he was the last chair. And he is Chief Justice of the National High Court of Brazil. That's the highest court in Brazil. And he's also the Chancellor of ICEL. I understand, Antonio, can you hear me?
Hello.
Justice Benjamin? No. I'll just look at our technical colleagues behind the glass there. If we're having a problem, we will move to our next speaker and just hold Antonio, but just let's wait for a minute. Gustavo, could you swap seats so
Yeah.
that you can get access to the microphone?
Yeah,
Why
of
don't you
course.
move over here? So, just move your chair.
Oh, no, they can just stand there.
Okay.
Just so you've got
Yep.
the microphone.
We can move on and then Antonio comes next. No?
Monty, would you like me to move to the next speaker or wait for Antonio? Move to the next speaker? Okay, so we're just having a bit of an issue with getting Justice Benjamin online. He will join us, but he will come after our next speaker. So our next speaker is Mr. Gustavo Alanes. He is the president of the Centro Mexicano de Derecho Ambiental. He's also a member of the ICIL Board of Governors, and he will be speaking to us about environmental defenders in Latin America. Over to you, Gustavo.
Gracias, John, and thank you, Monse, and everybody here at the university for having us today. I would like to share with you some of the results of the 2023 report that we did about the situation of environmental defenders in Mexico. We've been doing this report for the last 10 years, in 2014, so this is not a new exercise. We've been doing this for 10 years already. And unfortunately, the situation for environmental defenders, not only in Mexico, but in Latin America, Brazil, Colombia, and other countries, is not having a good time. And you will see why. The first thing that I would like to share is that there were 123 events of aggression against environmental defenders in Mexico. And this make the year 2023 the second year where they have been documented more events of aggressions about environmental defenders against communities that have the intention to protect the land, the territory, environment, and natural resources. Not only that, but also to say that this has been, 2023, has been the second year more violent for the defense of the natural patrimony, environment, natural resources, the land, in Mexico since 2014. Which are the most common aggressions? I would like to start with the threats, which is 33 cases, intimidation, 28, physical aggression, 26 cases, criminalization, 21, assassinations, unfortunately, 20, harassment, 19, and defamation, 18. If we compare the number of assassinations in the last years, especially the last 6 years, because in Mexico we changed yesterday to a new administration. We have a new president starting yesterday. But in the last 6 years of the presidency of López Obrador, 102 environmental defenders were killed in Mexico. 2022, 24, 2021, 25, 2020, 18. No? And just to give you an example so you can compare 2023 with other years. There were 57.7 aggressions against indigenous people and the members of communities. The more violent states with assassinations are the state of Michoacán with 7, Guerrero with 6, the state of Oaxaca and state of Mexico with 2, and the state of Hidalgo, Sonora, and Jalisco, 1 assassination in one of each of the states. Who are the victims? Who you think you are? They are. They belong to communities, 64%, members of civil society, 13%, peasants, 8.13%, academia, 4.6%, students, 4.6%, lawyers, 2.43%, and journalists, 1.62% of the cases. If we go by sector, we will find that mining is where there's more situations, 30 cases. Communication sector, 18, and forest, all matters related to forest, 13. Of course, there are other cases that have to do with biodiversity, with water, and also the energy sector. One of the things that concerns more is that when you get to see who are the perpetrators, no? When you get to see who are committing the aggressions, you will be shocked. No? It's the state. No? It's the state and municipality police. It's the Minister of Defense. It's the Minister of Marine, the National Guard. No? They have participation in 61% of the events. Then you have organized delinquency with 37 cases. And then there, in third place, you have 19 events that come from the private sector. Also, to let you know that in the statistics that we put out for 2023, there was a new methodology for the report, and we wanted to know who else is being affected by these aggressions. No? Because it's not only me as an environmental defender who suffers the aggression, no? Because this has an impact to others, to your wife, to your husband, to your kids, to your classmates, to the people that work with you at the office, to your friends, etc., no? Because it creates a threat, you know, it creates a lot of anxiety, anxiety. So people are afraid because others are suffering this kind of aggression. And in 2023, we registered 1,370 persons who were affected indirectly because of these aggressions. So after having all this situation just in Mexico, and let me tell you, Mexico is not the worst country. We have Brazil, and then Colombia, and then Mexico. No? So what needs to happen, just to start closing? We have to fight impunity. No? Nobody's in jail today because of these aggressions. No? So we need to go after all those who are committing these threats and criminalizations events. There has been a huge omission and silence from the government. They have no sympathy, they have no words of compassion, no words of being with the victims. No? So we hope that these things start to change, but impunity has to be fight. Also, I think we believe not only in Mexico, but in other countries, we need to have a very strong public policy to protect environmental defenders, which does not exist today. We also believe that we need to strengthen the official mechanisms that exist to protect journalists and environmental defenders, because it is important to mention also that they are killing not only environmental defenders, but also journalists. Many journalists have been killed in Mexico in the last years. And one last thing that we believe needs to happen is that we need to fully and properly implement international agreements, as it is the case of Escazú. No? For those of you who are not aware, because you don't have to know, but there's a new agreement in the Americas, which is called the Escazú Agreement, which is related to access to environmental justice, access to environmental information, and the possibility for the public to participate in the decision-making process. But not only that, but Escazú has an article, which is Article 9, which talks about environmental defenders, no? And it says that environmental defenders have the right to have a proper environment, no, to do their work without threats, without restrictions, and in a safe environment. It also says, Article 9, that the governments have to, the states have to take effective measures to protect the right to health, the right to personal integrity, and the right to free expression. And finally, Article 9 of Escazú, which is not comply, at least in the case of Mexico, says that the states have to prevent, they have to investigate, and they need to sanction the attacks, the threats, the intimidations that environmental defenders suffer. As I said, this last thing is not happening at all, no? So as you can see, the situation is not good at all, and I believe that a lot has to be done at the national and international level in order to try to reduce and stop this kind of situation. So thank you again, Monse, the university, John, and all the students and everybody here for having us today. Thank you.
Thank you, Gustavo, and thanks for all the incredible work you and your organisation do to raise the issue of the plight of environmental defenders and try and make sure it's recognised globally, regionally, and most importantly, nationally. Thank you for that. We have Antonio. Justice Benjamin, can you hear me?
Yes, I can hear and see you very well.
He's got a very soft
I can hear you.
Globally, regionally, and most importantly,
Can you hear
I
me?
don't hear him. Thank you for that. We have Antonio. Justice
Yeah, I
Benjamin,
am
can you hear me?
connected. I can see you, and yes, I can hear and see you very well.
That's all right. We've still got a couple of speakers to go, so we
I can hear you.
dropping him down the list a little. Have
Can
we
you hear
got
me?
him online, or do we defer for?
Yeah, I am connected. I can see you, and yes, I can hear and see you very well.
That's all right. We've still got a couple of speakers to go, so he's
I
worth
can
waiting
hear you.
for, I assure you. We will get there in the end.
Yeah, can you hear me now? Can you hear me? Can you hear me? Yeah, I am connected. I can see you, and yes, I can hear and see you very well.
That's all right. We've still got a couple of speakers to go, so he's worth waiting for, I assure you. We will get there in the end.
Yeah,
Monsieur, would you like me to go to the next speaker? Well, okay. So, he's worth waiting for, I assure you. Okay, so we still have a bit of a problem there. We will persist and we will get there, but while we're working on the technical issues, we're going to move to our next speaker, who is Professor Ben Boer. He's the chair of the ICEL Publications Committee in Sydney, Australia. He's visiting professor with Wuhan University in China. He's a member of the ICEL Board of Governors, and he's also had many other roles over the years. He's going to be talking to us about understanding the ecological civilization. He's the chair of the ICEL Publications Committee in Sydney, Australia. He's visiting professor, I think there's going to be a slideshow, is there? Board of Governors, and he's also had many other roles. Over the years, he's going to be talking to us about understanding the ecological civilization. Just minimise a few of these. Publications Committee in Sydney, Australia. He's visiting. I think there's going to be a slideshow, is there? Board of Governors. We're having to minimise everything. Over the years, he's going to be talking to us about understanding the ecological civilization. Minimise this one here.
Oh, it's right there.
I think there's going to be a slideshow. I will. We're having to just maximise the page. Okay, some technology worked. Bravo. Okay, over to you.
Thank you, John. And hello to everyone. It's good to see you here. Last time I was
some
in
technology worked. Bravo.
Madrid was 1976. Actually, the first time, I should say, not the last time. So a long time ago. Thank you, John. My task this afternoon in 5 or 6 minutes is to try to explain to you the idea of ecological civilization as the basis for new environmental law in China. Not the last time. So a long time ago. When I first went to China, I was very skeptical of the environmental law and how it was progressing. And that skepticism was justified. These days, I'm asked by people when they hear that I teach and research in China, they say, do you have environmental law in China? Well, I can assure you that the environmental law in China is now much stronger than it was in 1995 when I first went there. This paper, in very brief compass, talks about how ecological civilization is understood in China and what its potential might be at a national level and globally in terms of its implementation. One of the problems that I will show is that we have a difficulty with the actual definition of ecological civilization and how far it should go, what the scope should be. I will also talk very briefly about the environmental code that is being developed in China and its relationship with ecological civilization, and then to explore what pathways we might follow. My colleague Chen Zhou will be also talking about the detail of environmental law, so I will not transgress on her areas. Wuhan University sponsored a project in which I was involved a few years ago, and it's a picture of Wuhan University there, and that's where some of this learning comes from. The history of development of ecological civilization is quite a long one, and recent analysts from the 1980s onwards have traced it from Taoist and Buddhist and Confucian ways of thinking, basically thinking about how law should encourage humanity's harmony with nature, a bit like what Pax Natura is thinking about as well. So since that time, we see it has become a highly political subject, but also one that is a very serious subject for the development of environmental law in China. It's become a very important part of Chinese environmental law in the past 12 years. We won't go through all the background to this, but I will make this PowerPoint available later so that if you wish to read it, then you can. But basically, the National People's Congress has adopted this idea and is now pushing it forward in a very significant way. But basically, the ecological civilization, or EC, requires people to understand the symbiotic and harmonious relationship between people and nature. Now think about that. How many countries have actually thought about that as the basis for environmental law? I can assure you very few have done this at the most official levels, including with the president or the prime minister of a country. So basically, these ideas are very ancient ideas that are being transformed into the modern realm. The idea, the word of ecological civilization is Sheng Tai Wen Meng in Chinese, and it's got a very sort of specific meaning or set of meanings in China. I can't go through all of this material, but I'll just very briefly discuss one or two of the elements. We see that ecological civilization derives from other aspects of civilization, where the Chinese thinking is to do with material civilization, industrial civilization, economic and political civilization, and now finally ecological civilization, building on all of the past. So basically, trying to require human beings to treat nature in a more civilized way. Think about that. Maybe we should expect nature to think a little bit more about humans as well, in a very different way from the way in which we see that relationship developing now. So one of the things that one can talk about is the relationship between the idea of ecological civilization and sustainable development, and there are many links, but EC goes beyond ecological civilization. I won't go through all of this material. A lot of work has been done. Not only that, this idea has now been adopted in a range of what we call ecological civilization pilot zones around China, and I've listed some of them there. Basically introducing green ideas through green industry in various aspects of Chinese industrial society. The idea has been incorporated into all of these laws, and Zhenzhao will look at those later. We also see a legal recognition in all of these laws, and I won't go through the details, but tax law, environmental law, it's been incorporated into the Chinese constitution. Can you imagine other countries doing that? Well, I hope they do. The problem, though, as I've said, is that the concept is rather abstract and at this stage lacks legal definition, and this is where I should think about then the idea of the Chinese Environmental Code and ecological civilization, where the basis of this new code, this comprehensive code for the whole of China, will incorporate this idea of ecological civilization. And my argument is that unless it is adequately defined, it will be much less useful because people will not know what it actually means. When a judge or a lawyer or a developer needs to understand what we mean by ecological civilization, we need a legal definition. That's my argument. I don't know whether I'm going to be successful. Nick Robertson's view in writing about this a couple of years ago in a big seminar that we ran back in 2019, just before COVID hit us, he said, China can contribute greatly to the global debate about Earth's ecological principles of law, which Nick was just talking about, by sharing its knowledge and understanding of its increasingly accepted concept of ecological civilization. But to attain it, we all need to cooperate together. Well, hear to that. That's what we need to do. One of the questions is whether or not this idea can contribute to the development of international environmental law. I'd say, well, there is rhetoric and there is reality. And the reality is that a huge amount of work needs to be done before it can be incorporated. So my conclusions are that certainly the idea goes beyond sustainable development. We need to think about it, though, in a much more serious way in terms of its definition as an ethical driver of the whole policy and legal development approach in China. So the future is one that looks good for this concept, but we really need to be much more serious about explaining what it actually means. Finally, then, one of the questions would be whether or not it can be more effective than sustainable development, and also here's a challenge for us in the International Council of Environmental Law, whether we should initiate a research project to look at whether or not these ideas behind ecological civilization, which have been written about by hundreds of academics now in China, whether or not it can feed into a more global idea of thinking about how we treat the environment, how the environment hopefully will treat us. Thank you.
Thank you, Ben. Really interesting. How many people here have actually been to China? Anyone here visited China? Back? A few? Just a few? You know, the interesting thing, I've been there many times over the past 20 years, and Ben's talked about the law and the government policy. You see the transition in China towards an ecological situation. You see it with your eyes. When you read the China Daily on a daily basis, half of it is about ecology. I don't see that anywhere else I go when I read local papers, that half of it is there. It's a very interesting transition to see. Is Antonio? We lost him. All right. Now, just going to pause for a minute because you've got a PowerPoint. Let me... it's the same one, is it? No, okay. Is it there or not? No. Okay. Okay. You happy with that? Yeah, continue.
Continuous.
El capitán.
This one here?
Tony, el capitán.
Whoops, there it is. Let me just introduce you first, and then you can sit here. So thank you for that. We'll keep trying with Antonio, but it's not looking very promising at this stage. I will move to our next speaker. Ben's already made reference to her, Professor Chen Zhou. She's the Associate Professor of International Law at Xiamen University in China. Come over. Yeah.
Thank you, John. Good afternoon. It's my honor to give a presentation here, and I continue the topic with my colleagues, Ben, and this is the topic of my today's presentation. Almost 50 years ago, China participated in Stockholm Conference, and after that, organized the first national conference on environmental protections 50 years ago. That started China's protection of environment. And 10 years ago, China comprehensively revised its mother environmental protection law that introduced the really crucial principles and mechanisms and rules, and also some procedure rules like public interest litigation. And after that, China started 10 years really rapid and intensive environmental legislation and judiciary practice, which I would like to share with you today. The first part I would like to share is about the significant characters of this 10 years environmental legislation in China. So first, the obvious characters of legislation is a holistic approach. This is China aim for the systematic governance, which combine that all kinds of the nature elements and the environmental medium, and that is started lawmaking on that, which covers both climate change mitigation and adaptations. I give you one of the examples here. So one of the several laws about to protect the river basin, for instance, like Yangtze River and the Yellow River, that is China mother two rivers. So the laws is particularly targeted on that two big rivers. And as a result of this holistic approach, that is, as mentioned about, it's China's environmental codification that is doing right now. So this environmental code that confirms sustainable development as its legal objectives, and it has a separate special chapters, particularly about green and low carbon development, that's chapters, and also introduce that a more comprehensive and a unified approach, this environmental accord. Another crucial features is about the multiple instrument targeted. For instance, that under that two mountains ideal, which targeted on to assess and realize the ecological products and functions, and to realize that the values of the nature capita. Under this, China enact several laws. As one of the law mentioned by Ben is environmental tax law, and also that regulations on compensation for ecological protection laws. Those laws try to promote that economic incentives. And also that environmental legislations now focus on the closser interact with other sectoral law. For instance, the civil law, civil code. The civil court introduced that green principles, which require that that private sectors conducted their civil activities in the manner of saving more natural resource and protect the environment. And also in this court, they have separated chapters about eco-environmental liabilities. And just last years, the company laws are newly revised. That introduced that the corporate social responsibilities to prepare better for the ESG. And this is a record to that administrative measures for the legal disclosures of enterprise environmental information. So in these measures, there is a requirement about that emission information disclosure. And besides that, also criminal laws interact with environmental law is not focus on that the environmental data falsification. So not only the crimes, but also that more details like amendment to criminal law. I made for instance here at the 11th Amendment, which expanded that the subject of the provided environmental data like into that EIA. And the environmental monitor agencies. And also there are more detailed judicial interpretations on this. Also the procedural laws are revised to accommodate the civil and administrative public interest litigation, and on which several environmental cases and also the climate cases are launched after that. Another feature is about interactions between the policy and the law. Here I want to say something about legalization of the policies. So this is the major areas, particularly concentrated on green and low carbon transformation, which try to enabling micro and macro environment to force enhancing all-round capacities. So not only that national strategies, but also that sectoral and also intersectoral efforts are made in this area. This is example I want to go to further in it, but one of the examples I want to say here is that is 13 sectors altogether that issues that the national action planning programs for healthy adaptation to climate change just recently. Another feature is come from that core efforts from the social norms. So this is the one areas that ecological civilization works. So the citizen pact and also norms that I made. For instance, and last year that the education ministries and also the the women union and also the eco-environmental ministry altogether, they issued that citizen behavior norms, particularly on eco-environmental protection, as you can see that in the corner of the pictures, that about your how to your lifestyles, it's behavior norms. And local level, province levels, for instance, like Fujian, they have the locals. Fujian is a pilot environmental, pilot programs under ecological civilization. So 2 years ago, they have the measures to require that the big activities and official meetings organized in a carbon neutral way. So required by this, that at that year the International Women's Festivals activities, there is a carbon neutral ones, so they get certificate. You can see it on the green certificate, the carbon neutral one, with. So very few words about the judiciary practice, and that China is well known for its specializations in environmental justice. The Green Court, you heard about that, the 4 levels. And the Green Courts that they have brought the case scope from traditional one, and also that newly emergent, the new cases like dual carbon targets and green transformation. And also that Supreme Court also that played Euro functions as to issue the judicial interpretation. So there is a judicial interpretations about to open the door to the preventative public interest litigation, and also that recent interpretations is like 2024. There is a interpretations on the forestry resource civil case. So in this one, it's try to innovate that legal liabilities to to purchase subscriptions of the certificate carbon sink can be used as an alternative so for fulfillment of liabilities. And also there are some cooperative actions with Supreme Court and Supreme procurations, and targeted on that the data falsification. And also the Judicial Court also issues some that normative working documents. For instance, they are working documents to define and clarify climate change litigations. And also there's documents to give the guidance how to hearing the relevant case. And in addition to that, to publicly release the guiding cases, like 11 cases are issued by the Supreme Court, which covers the cases from that renewables and green principles and emission trading, illegal deforestation, etc. And so my last slide is about also that the judicial practice focus on that international cooperations. So that the cooperations, they're working on that, for instance, Kunming declarations about World Judicial Conference on Environment. So this one is required to address climate change case. And also that intersectoral and across regional actions also also happens. For instance, that is joint actions between the court, among the court and public prosecutions, and also some administrative authorities work together to maintain and enhance the carbon sink capacities. Thank you. That's what I want to share with you.
Great. Thank you very much, Shen. And we're now going to get a video presentation. I'll introduce the speaker while Montse is getting the file up. It's Professor Koh Ken Liang. She's the Emeritus Professor of Law at the National University of Singapore. She's a member of the ICEL Board of Governors, and she is former Director of the Asia Pacific Centre for Environmental Law. She'll be joining us via video, and she'll talk about the ASEAN Declaration on Environmental Rights 2024
A very good
and
day to
ethnic
all
communities.
Of you.
That sounds
the
like
title
Koh Ken
of my
Liang.
presentation is Draft Us. A very good day to all. A very good day.
There she is, and we'll hear the audio.
Hey to all of you. The title of my presentation is Draft ASEAN Declaration on Environmental Rights 2024, hereafter ADER, and ethnic communities. The ADER draft, dated 7th March 2024, is a watershed declaration. Its aim is to implement the right to a safe, clean, healthy, and sustainable environment by providing for 1. Meaningful public participation in decision-making of stakeholders, including ethnic communities, in accordance with international standards, national laws, and policies. 2. Human rights-based approach in environmental assessment. The term ethnic communities, ECS, is not defined in ADER, but is generally understood as, to quote, a social group or category of the population that is set apart and bound together by common ties of race, language, nationality, and culture, unquote, and includes indigenous peoples. ADER recognizes that due to their centuries of interaction with nature, they experience living in harmony with nature. ADER is in alignment with many emerging global instruments such as the Paris Agreement and the Kunming-Montreal Global Biodiversity Framework, which protect various groups including women, youths, and persons with disabilities. Such groups are often subjugated or marginalized. ADER focuses on the preparation of special measures and procedures for people in vulnerable situations and with disabilities to ensure meaningful participation. ECS face many environmental vulnerabilities, including from industrial development and climate change, resulting in dispossession and or environmental degradation and existential threats. Such factors also impact on their traditional ways of living in harmony with nature, not only in cultural but also religious practices. There have been many environmental defenders, but they are often confronted with violence and even death. They are often unrepresented in intergovernmental or other platforms. To give effect to meaningful participation, ADER recognizes public participation to be held at the earliest possible stage before decisions are taken, and while options are still open to the preparation of decisions on proposed activities, permits, and other measures, plans, programs, budgetary matters, draft laws, regulations, and policies that may have a significant impact on the environment. The specificity given of meaningful participation is amazing and not just a framework provision as one often comes across. This promotes and supports the rights of women, children, youth, including people with disabilities. What then can be considered disabilities apart from obvious ones? There are many ECS in ASEAN who live in remote areas. Many do not speak English. Can living in remote areas, which may require them to travel long distances to attend meetings, and the language problem, be considered disabilities? I think so, and the measures to overcome these disabilities should include funding the cost of travel and interpreters. These costs may be high, as there may be many meetings and subsidies may be needed apart from government funding. Another disability are obstacles faced by environmental defenders who may be subject to violence and even death. Under ADR, any person who exercises rights under it will be protected from threat and retaliation and will not be subject to civil, administrative, or criminal proceedings. Effective and timely measures, such as establishing response mechanism at ASEAN and national levels to effectuate such protection, should be in place. A final word on meaningful participation. Knowledge of environmental law is imperative. It is therefore crucial to build capacity in environmental law of relevant stakeholders in the ASEAN member states. Thank you very much. Before I leave the platform, I would like to say a big thank you to Nick, who devoted his passion and commitment to ICEL. He also made enormous contributions in the ADB, IUCN, CEL, UNEP, NUS Faculty of Law Capacity Building Project. This led to the publication of Capacity Building for Environmental Law in the Asian and Pacific region, approaches and resources, published in 2002. I also welcome John Scanlon. I can think of no other better person to continue the future work of ICEL. I look forward very much to working with you, John, as I did in other projects. Thank you very much.
Wonderful presentation by Professor Koh, and I know you can't hear me, but I look forward to working with you as well. I'll speak to the photograph. That was wonderful. We now have 2 of the 3 listed discussants who are with us. Okay, great. We have Dr. Digno Montalavan. He's a postdoctoral researcher here at the university, and Dr. David Uriel Sokol. He's the assistant professor with the Hitotsubashi University in Japan. They're going to offer some observations, and then we're going to open it for questions. So if you use the lectern, that'd be fantastic.
Thank you very much. Thank you to Professor Abad for the invitation to this amazing panel and have the opportunity to be a discussant after such an amazing speakers. About the discussion that we are having here, I would like to present the importance of the international litigation in human rights when we talk about environmental protection and more specifically about climate change protection. And I would like to focus on the case of the Inter-American Court of Human Rights and how the Inter-American Court of Human Rights can also speak about the role of science, the importance of the environmental defenders, and also how the Inter-American Court of Human Rights contributing to the construction of a new ecological citizenship through their rulings. The Inter-American Court of Human Rights has talked about the relevance of the environmental protection for the human rights since 2001 in a case called Aguastigny versus Nicaragua of 2001, a case about indigenous people's rights. And since 2001, the Inter-American Court has developed a lot of relevant legal precedents about the interconnection between the environmental protection and human rights, taking into consideration how environmental damage can affect human rights such as the right to life, health, and between others. But not only, also the court has taken into consideration the importance of procedural rights, has the right to the access of information, the right to a fair trial, or the right to participation to improve better environmental decision making processes. During almost 17 years, the Court has developed a lot of standards about it in different cases, mainly about or related to indigenous people's rights issues. But in 2017, the Inter-American Court of Human Rights launched the advisory opinion 2317 about the right to a healthy environment and human rights. That is an amazing advisory opinion which established some of the, I consider, most relevant precedents in the international human rights litigation regarding environmental protection. For example, the Inter-American Court says that in transboundary environmental damages, the country who is in charge of the protection of human rights is the country that can avoid that environmental damages. So the transboundary environmental damages is something that the Inter-American Court has already speak about it. Also, the Inter-American Court, in that advisory opinion, in 2317, talk about what they call the right to a healthy environment has an autonomous right, which, according to the Court, looks to protect the environment for the interest that the nature and their components has in themselves, which is a more ecocentric view through the environment. So through this development, the Court is, I consider, working to the implementation of the framework of the rights of nature within the Inter-American human rights system. And also more recently, in a very interesting case, the case La Oroya versus Peru of November 2023, the Court sets the principle of the intergenerational equity, according to which the Court says that we, the current generation, have an obligation to preserve the rights of the future generations. And in this regard, the Court is also giving steps to the recognition of the future generations as a subject of rights, which is something that we can debate because it's a little bit problematic also. But it's going there. And also in the remedies of the case La Oroya versus Peru, the Court established long-term remedies, terms that have to be followed up during 30 or 40 years later. So it's a very good case in the international environmental environmental litigation. And finally, in December this year, probably the Court will launch the advisory opinion about climate emergency and human rights, which is a highly expected advisory opinion because the Court has to face some challenges, some at least theoretical challenges to speak about the climate change, mainly because of the competence of the Court. For example, the Court only can rule for the 20 countries that had accepted the contentious jurisdiction of the Court and the obligation that exists between them in relation to the American Convention of Human Rights. But the climate change commitments are global commitments, so it's not clear until what extent the Court can establish obligation to global commitments that goes beyond the specific agreements that are part of the Inter-American human rights system. But not only that, only the Court faced what has been called the ontological limitation of the human rights approach to face the climate change or to make it compatible with the climate change law. What I mean by the ontological limitation, traditionally the human rights approach or the human rights litigation looks to protect or to give duties or obligations to the states in front of their citizens within their territory. So the question keeps open about to what extent the human rights framework can give answer to a global problem if they have the limitation of the jurisdiction within the scope of the national territories. Finally, I would like to mention also the debates about the problems that creates the fragmentation of the international law. The climate change law and the human rights law are a framework that has been developed separately, and that has made also that has produced also a lot of tension between both. Indeed, in the Inter-American human rights system right now, there are 13 cases related to environmental policies in the face of fight against climate change that has probably violated human rights. There are cases that right now the Inter-American human rights system is looking for. So the relationship between the climate agreements or commitments and the human rights, it's at least not peaceful fully. And finally, the role of science and human rights. in the case of the Inter-American Court of Human Rights, and the science, something that has been also mentioned here, one big question that the Inter-American Court has is, to what extent within the definition of science, we can include the indigenous knowledge, which are a big part of the Inter-American human rights system. Indeed, the environmental cases came into the Inter-American human rights system because of the indigenous advocacy. So to one extent, when we talk about climate change or environmental protection, we can also give or open the door for indigenous knowledges, especially when they create tensions with the traditional Western knowledges. I think that this answer will be, or probably, will be given by the Inter-American Court in the advisory opinion about climate change and human rights, and we will see what the court will say, but doesn't matter why. I think that the debate will continue. Thank you.
Thank you very much. And our second discussant, David.
Bend over a little bit. Can you hear me? Yes, brilliant. Hello, everybody. My name is David Sokol, and I come here in front of you today as someone who not too long ago was seated in your same seats. I was a student at Carlos III, and here is where my trajectory towards environmental law and sustainability law started. I come here not to give you one specific note on the development on regulatory issues, but more to speak on the importance and flexibility and nuance of environmental law and sustainability policy internationally and interdisciplinarily. So I started my career here in Spain in the Ministry of Foreign Affairs, where even in diplomacy issues, there were components of environmental law throughout. Then I transitioned to a couple of different law firms. I worked here in Spain, I worked in Norway, I worked in Hong Kong, I ended up working in New York and throughout the United States and internationally, both in finance, international finance, and in technology transactions. Throughout the entirety of my professional trajectory as a lawyer, as a transactional lawyer in mergers and acquisitions, capital markets, there were always environmental law components. And they were often the most relevant and fulfilling components of the deals that I was on. From mining to infrastructure, most of the deals and transactions had environmental law components. And being informed not only gave a young lawyer an advantage, but also to me spoke volumes about the ethical integration that corporate responsibility should have as one of its anchoring pillars. Additionally, I also served in the Latham and Watkins Pro Bono Committee, where not only did we incorporate sustainability and environmental components into our deals, but we also had that as a specific angle. We have an entire infrastructure focused on pro bono matters, which included environmental law. Now that I am a professor in Tokyo, I focus on the intersection of law, technology, and sustainability. And just to give you a broad overview of the ways in which you can develop your passion and your expertise, 4 of my core components of the research that I pursue is in artificial intelligence. So first, I'll list them and then I'll go through them. Artificial intelligence, renewable energy, biosynthetic cellular tissue replication, and critical minerals are 4 of my most relevant sustainability components of the research. First, in artificial intelligence, with regards to smart cities, intelligent societies, there's a tremendous amount of opportunity for the integration of new technologies into sustainability. Let's look, for example, at mobility and transportation. If you establish appropriate regulatory frameworks for autonomous vehicles and you reduce emissions, fantastic avenue for sustainability. Then secondly, with regards to renewable energy policy, of course, this is the most obvious and tangible one. If you transition away from oil and gas and traditional consumable resources into renewable energies, then you can affect change. Thirdly, biosynthetic cellular tissue replication, which is cellular agriculture, is a new way of feeding the cities of tomorrow. resolving a lot of the issues that are currently plaguing our food resource systems, like massive water usage, tremendous amount of land usage dedicated to growing crops for livestock. All of those seem to be able to be resolved through cellular agriculture. And then lastly, critical minerals, crucial for technological development, all the things that make up your computers, your phones, renewable energy battery and infrastructure. Well, those require critical minerals, and at the moment, it seems that they are being acquired at any cost throughout the international landscape. Another one of the components that I do here is balancing the need for these critical resources with the sustainability purposes that we all ascribe to. The reason that I tell you this is because I think that when people hear about environmental law, they think about it narrowly. They think about it as one very specific mode or nomenclature, system, mechanism, perhaps somewhat diffused at an international law level and then only practicable at a jurisdictional national level. This is one of the avenues, but you can forge your own path. If you truly believe in sustainability and environmental law, you can approach it from any angle that you think is worthwhile or that you're passionate about. And many of these components, both as a lawyer, as a practicing lawyer, through your deals, or whatever path you choose to pursue, this is an opportunity and perhaps a responsibility and a duty that we all have. That's what I wanted to share with you today. I'll keep my time brief. If you have any questions or want to know more about some of my research projects or just interested in studying abroad in Tokyo, which is admittedly very cool, you can just let me know. Thank you to the fantastic panel for incredible presentations. Thank you to Montse for the organization and for the time to speak. And thank you all for listening. That's my time.
Thank you very much. Okay, we've got about 10 minutes for questions. We've had extraordinary panel discussion, discussants adding their perspectives. We've gone right across the globe, across all regions, had deep dive into different countries. We've seen progression, we've seen regression, and everything in between. So now's an opportunity for you to ask any questions of anybody or offer any observations. So do we have any takers? Don't be shy. You know, there's a prize for the person who asked the first question. It's a really good prize. Okay, no questions? Comments?
Hello, excuse me, can you hear me?
Yes, we have someone online.
My name is Laura Carvalho. I was also invited as a discussant, but regrettably I couldn't make it in time for me speaking. Now I am looking at myself on the mirror. That's interesting on the screen. Anyway, I have a question for the panel. Although I couldn't be here, I am noticing that we are getting better and better in addressing sustainability from a holistic perspective, meaning that more and more we have more discussions about human rights litigation, as Digno was mentioning before, and we are understanding better that humans are not possible to be discussed without the other part with environment. So social and environment go hand in hand. So I would like to ask to the panel whether you have changed or you have examples about how we can get better in this holistic approach to sustainability. I know this is a general question, but for example, I have been feeling or I have been experiencing that that path in fisheries, for example. We have a lot of discussions about IU fishing, about how to tackling illegal fishing. Now we are discussing fisheries from the forced labor perspectives and the bonded perspective. So you can see that both sides goes to the same in order to protect the environment, at the same time keeping safe the people that is fishing in this example. Can you provide more examples about this holistic approach to sustainability and the manner how it is being addressed, not just from the perspective of environment, I mean?
Thank you, Laura. Excellent question, and we heard you loud and clear. So I'll look across the panel and see if there are any. Nick would like to have a first go at responding to that, and then Ben.
Well, thank you for a very important question, and one which we've been struggling with for a long time, since the beginning of environmental law, because environmental law tends to be, like other fields of law, very segmented. It's in a silo. We worry about water law. We worry about pollution for the air. We worry about nature and protected areas. And that's not the biosphere. The biosphere is all of this united together. So we began with a practical sectoral approach to solving specific environmental problems, not from an ecological approach, which is everything is linked to everything else. So we first have to begin overcoming that, I would call it a bias. It's not prejudicial, it's just reality. We created a field of law based on prior fields of law, the way we did it in the past. We now have to integrate across these fields of law. The International Tribunal for the Law of the Sea last May issued a very important advisory opinion on climate change and the law of the sea. And one of its findings was that when you pollute the atmosphere, you're actually polluting the ocean, because the sea and the atmosphere are one system. Where has most of the carbon dioxide gone from the Industrial Revolution? Into the oceans. We have the acidification of the oceans. So in the UN Convention on the Law of the Sea, Article 92, it says you cannot pollute the ocean. You have to save the ocean, protect the ocean. So when you pollute the air, you are actually violating your obligation to the oceans by creating a pollutant that is changing the oceans. The same thing is happening with heat. The heat that comes into the atmosphere is changing not just our cities and the very bad heat waves we have, it's heating up the ocean. We have underwater heat waves. We have terrible heat pollution that is killing large amounts of life before the water shifts and the heat dissipates. So everything is connected to everything else. Now, how do you do that when you're practicing law for a client? The basic fundamental is that you must help the client understand everything is linked to everything else, and that if you ignore an area of impact, the people who you damage are going to come after you sooner or later. They're going to complain politically. If they have a property interest, they're going to complain that you've had damaged their property. If they are representing nature and just wild conditions, they can create a political movement that addresses what you're doing as antisocial. You don't want your client to be put into that situation. So the individual transaction can integrate. You don't have to wait for the government to tell you to integrate. It's all connected already. You just have to act on that basis. So that's one practical way to take the holistic approach and put it into a practical context.
Thank you, Nick. Ben?
Well, I see it a little bit differently, I guess, in terms of thinking through what is sustainable and what is unsustainable. And we as environmental lawyers and policymakers and scientists need to think through the root causes of our present global environmental dilemma. We need to think through a much more holistic and integrated approach by which we attack the environmental issues in front of us. And this means looking at the whole of our environmental law systems at international, in particular at regional level and then at national and local level, and saying, are we using the right words and phrases and definitions? What do we need to change in order to change the systems? I'm thinking here not just of the legal world, but we need to also think about the political, the economic, the scientific, and the social worlds, all of which need to be understood in a different way in order to attain sustainability. If we don't do that, if we don't look at the actual root causes of our environmental dilemma, we're not going to get anywhere, and we're going to continue to have business as usual. This is a huge task, but it seems to me, from the point of view of environmental law education in particular, we need to start asking the questions, and for young and old to think through different ways of approaching the issues, different ways which actually really do mean sustainability. Thank you.
Thank you, Ben. That's great. Let me see, anybody want to take up the opportunity for a question or an observation? I'll just say we did see a shift from in the whole way in which we described sustainable development. Remember, we used to talk about the 3 pillars, like 3 separate pillars. Then we started talking about 3 dimensions, because they're intertwined. And actually, Angela Cropper, who is well known to all of us, the late Angela Cropper, was very much the architect of that shift of thinking. Not pillars, but, you know, they're intertwined. I'll give you an example with environmental crime and wildlife crime, but I'm going to do that when I speak in the next session, so I'll hold that in terms of how we're seeing a convergence across different disciplines. So we've got a coffee break coming up, but if anyone had a burning question, yes, we have one here. Well done. Bravo. Excellent question, and we see it not just in the Ecuadorian constitution, we see it with biodiversity, climate change, desertification, the aspiration or the legal commitment compared to what is happening on the ground. There's a big gap between them. I saw Ben gave me a little wink. I think he wants to have a go at this one, and then I'll turn to others. But excellent question, thank you.
Just very briefly, the whole Pachamama movement that we saw in Bolivia and Ecuador 10 and 15 years ago basically failed, it seems to me, because of the lack of understanding by judges, lawyers and others in terms of saying, what did Pachamama mean in terms of the relationship of humans and nature? And it seems to me this is where we need to reinvent environmental law education in order to actually look at the fundamentals of what we're trying to do. The natural environment is the only basis for sustainability of people and the rest of the environment. And therefore we have to redesign the environmental law curriculum for people to understand that from now onwards, in order for judges and lawyers who are arguing these cases and looking, for example, at the constitutional provisions in Bolivia and Ecuador and saying, this is what we understand, this is how we have to apply it, rather than to ignore it, which is what has actually happened.
Thanks, Ben. Thanks, Daniel, for the question. I don't think anyone else was going to make an observation there. I've got a question at the back. I know we're going to break for coffee, but people are getting warmed up, so we'll let a few questions come forward.
So my question would be, what is the difference when we talk about scientific uncertainty? What is different in approach regarding the precautionary principle between the regions that the panel talked about?
Good question. And your name was?
Jose Manuel.
Jose. Gracias. Okay, who would like to pick that one up? Eckhard? Eckhard, you might have to... You can say then, Eckhard, come here. There you go.
Oh yeah, sorry. As regards the precautionary principle, that should be integrated in the principle of sustainable development, especially the ecological part of this principle. So there, I don't see any problem on based on principle. And if I look at the German climate change litigation, the decision of the Federal Constitutional Court, although they did not name the precautionary principle as being a precautionary principle, they relied on a precautionary argument. So I think that can be integrated into the concept of precaution. I see no objections based on principle against doing that. I wanted to come back to the integration, the idea of integration. Of course, everything is dependent on everything. That, I think, is a banality. But to devise instruments that can adequately tackle the problem of integration is extremely difficult. Of course, you can make a review of your whole system of environmental and other economic regulation under the perspective of integration. And you can then possibly identify parts where you have to make improvements. But if I look at the European experience with integrated prevention of and control of pollution, which already exists, it has turned out that it's extremely difficult when you have to take the decision to give preference to one kind of risk or one kind of damage over another kind of damage. How are you going to do it? How can you compare apples and pears? That is very difficult. So I think at the level of devising adequate regulation, integrative thinking is worthwhile doing, and we have deficiency in this respect. There's no doubt about it. But the idea of being able to tackle this problem with a single instrument, you cannot do that. If the owner of a facility asks for permission for air pollution, then you can, of course, consider also the impacts of the facility on waste and on water, and we are already doing that to a certain extent. But the question then is, which concern do you give preference if there's a conflict? And normally there will be a conflict. That is the problem we have not yet really found a solution for. Thank you.
Excellent, very good point to finish on. So it's almost 10 past 5, it is 10 past 5, and we're due to break for a coffee until 5:30. Then we'll be resuming for another session that will be just as exciting, if not more exciting than this session. So I hope you all come back after a nice cup of coffee, refresh yourselves. But firstly, let me thank all of our panelists and discussants, Monty, the university, everybody for pulling this together. It's been a great session, and thanks for your participation.
All right, we are going to begin. If you can take your seats.
Unfortunately, it doesn't work.
No, I know. So we have a very interesting opening for the second part of the symposium. And one of the interesting, por favor, amigos. One of the interesting aspects of ISIL is that it views nature and the protection of the environment as something which is also protecting art and culture. So the environment is not just nature, but how people see nature, how they interpret nature. And in this case, the works of art that you saw this beginning of the panel with Tony Oposa and his song, all the paintings of nature in that video that had the words on it were painted by an artist who's sitting in the front row, Tony Oposa. And one of the things that Professor Ko-King Lien did for ISIL was to encourage the gentleman whom you see on the video, who is Maestro Amos Chaya. He's from Singapore, but he's been conducting orchestras in Japan, even in Russia before the Ukraine invasion and elsewhere. And he has been designated by ISIL as our representative for music and culture. So he has created entirely new music as a composer to try to interpret what is happening to nature in the world. And then when we had our meetings in Oslo or our meetings here in Madrid and so on, he contributes this music to help us think about nature through music, because humans have been dealing with interpreting nature through music or through art since we first lived in the caves, a very long time ago. So let us play Maestro Chaya's composition. Reflection on what we leave the earth if we don't care about the earth and don't make environmental law more effective. So he will make more compositions for us to reflect upon in the future. And in the panel we have now, we'll go straight to the speakers. I'll follow the lead of the chairman of the first panel and not give long biographies, because you can Google their names and find them out. But John promised us a number of thoughts about wildlife crime, and so without further ado, I pass the baton on to John Scanlon, who worked for many years for IUCN and also for the Secretariat of the Convention on the International Trade in Endangered Species, CITES, which is a treaty that IUCN helped promote and write and get adopted. So his DNA is strongly involved with ISIL. Thank you very much, John.
Thank you very much, Nick, and thanks for sharing that wonderful video to get us started. And great to see so many people back in the room this late in the afternoon. Thanks for joining us. I decided to change my presentation a little bit, having heard the question from Laura in the last session, and I'm going to speak a bit about crimes that affect the environment more generically, and then shift into a bit of a focus on wildlife trafficking. Now, the reason being is I think this will help us see the nexus between environmental law, international environmental law, and international criminal law, and how they're starting to converge. It's actually quite an exciting time at the moment for the reasons I'll explain. Now, in May of this year, the UN Office of Drugs and Crime released the first ever global analysis of crimes that affect the environment. And they looked across 193 states, and they looked at international law, they looked at regional law, national law, and subnational law. That is not easy to do. And they did a great report. It's available. It was released at an event that was hosted by Germany and France in Vienna at the UN Commission on Crime Prevention and Criminal Justice. I was invited to speak there, and there's some extraordinary work that's going on. Now, there is no definition of what crimes that affect the environment are. It's an open-ended phrase at this stage. But what this analysis did is it did a deep dive into 9 particular crimes. I'll tell you what they are: deforestation and logging, mining, air pollution, noise pollution, soil pollution, water pollution, fishing, waste, and wildlife. Now, what this analysis showed is there is a large body of law at all levels for dealing with these 9 particular crime types, but they've developed in a very ad hoc way over time at all levels. Also, the motivation for creating these laws was not always to protect the environment. For example, some of these laws were about exploitation of natural resources and ensuring that states were receiving a royalty in response to allow the extraction of a natural resource. But in 2024, what we can see is there is a common thread across all of them. And that common thread is that a breach of these laws represents a crime that is affecting the environment. Now, what we should remember is that not all activities that have a harmful effect on the environment are illegal. In fact, a lot of perfectly legal activities have a huge impact on the environment, conducted by people and legal persons, natural and legal persons. And so this evolves over time, though. And what we've seen is that what was lawful some time ago is now becoming unlawful. So if we were sitting in this room 30 years ago, you might have an ashtray in front of you. You might be having a cigarette in here. That was quite lawful. You can't do that today. The state that I grew up in, Australia, if you had a lease over rural land, you were obliged to clear all the vegetation off that land or else you lost your lease. Now, fast forward to 1980, and what happened is the government prohibited all clearance of native vegetation, and that was under threat of criminal prosecution. So we went from not only authorising something, but encouraging something, to making it unlawful at threat of criminal prosecution. Now, so things evolve, and these things are going to continue to evolve. What's lawful today, in 10 years' time, may well not be lawful. Now, this global analysis goes across 1,400 multilateral environmental agreements. They're not all global agreements, some are regional and some are bilateral, but 1,400 multilateral agreements. Now, there are only 2 of these that oblige states to either criminalise or penalise a failure to comply with provisions. Of all of them, there's only 2. The Basel Convention on Transboundary Movement of Waste obliges states to criminalise failure to comply, and CITES, the convention Nick just referred to, the Wildlife Trade Convention, obliges states to penalise failure to comply with the convention, not criminalise. They're the only 2. All the rest are silent on these issues of enforcement, criminalising or penalising. Now, the interesting thing is the analysis shows that of all of those agreements, the 2 areas where you see states at a national level had chosen to criminalise certain behaviour is in relation to waste and wildlife. These 2 international conventions and the obligations to criminalise and penalise has filtered down to the national level. They are way ahead in terms of statistically what's happening at a national level. Now, I want to dive in. I haven't got much time. I could say a lot more about that global analysis. I don't have time. I want to do a little bit of a deep dive into wildlife trafficking and why I say wildlife trafficking is so important. The first thing is that when I talk of wildlife, I'm talking all flora, fauna, and fungi, all animals, plants, and fungi. For some reason, at the international level, we disaggregate wildlife. We have wildlife, then we have timber, and then we have fish. What's the difference between a fish swimming in the ocean, a tree growing that happens to be utilised for timber, and an elephant migrating across the savannah. It's all wildlife. But for some reason, and I think I know why, it's mainly the influence of commercial lobby, we've disaggregated fishery crime, logging crime, wildlife crime. So I talk about it together. Now, if we aggregate it, why should we be worried about it? Look at it in terms of its scale, its value, and its impact. In terms of scale, there have been 7,000 species of animals and plants found in illegal trade since 2016, and these species are protected under CITES. So of the 40,000 species protected under CITES, 7,000 been found in illegal trade since 2016. But the UN tells us that it's not just those species, there are millions of other species not protected under CITES that are found in illegal trade, in particular fish and timber species. Now, if we, and I can give you examples of scale, 100,000 elephants were killed for their ivory over 3 years. There's 200,000 pangolins being poached every year for their meat and scales, and I could go on, don't have time. Now, in terms of value, the value of the contraband, this is the value of the contraband, if you add all plants, animals, and fungi, is a massive $200 billion a year. That's the value of the contraband. It makes it one of the most valuable transnational organised crimes on planet Earth. But what's even more interesting is to look at the impact, not the value of the contraband, the impact of this activity. The impact is valued at between $1 and $2 trillion a year. Now, that figure was arrived at because of the impact of poaching and smuggling on ecosystems. When you deprive an ecosystem of its plants and its animals and its fungi, it depletes the ecosystem. It can't provide the same services. So in terms of carbon sequestration, water filtration, and the ability to provide wildlife-based tourism, it all goes downhill. That's why the World Bank said $1 to $2 trillion a year is the impact of this. But that's not the only impact. At the moment, you know, we're having a lot of discussion about biodiversity credits, carbon credits. There's more and more discussion around these things. There's a discussion in Australia in a week's time in Sydney. But what happens here is the efficacy of these credits are completely undermined by wildlife trafficking. If you look at nature-based carbon credits, they assume that that ecosystem will stay intact. If you have high levels, industrial scale wildlife trafficking, that whole notion or the whole rationale behind what that credit was going to deliver is completely diminished. The other thing that we need to look at too is the impact on human health. Pathogens spill over from wild animals to people and can lead to a pandemic. It's already happened. We know it's happened. It happened with HIV/AIDS, happened with Ebola, SARS, MERS. The latest scientific report says the origins of COVID-19 were from wildlife. Now, that risk comes from legal, unregulated, and illegal trade, but illegal trade bypasses all biosecurity measures. We are at high risk through wildlife trafficking of the next pandemic. They're the reasons why we want to do more. And I'm going to conclude by saying this. We have no global agreement on combating and preventing wildlife trafficking. Doesn't exist. We created the Global Initiative to End Wildlife Crime in 2020. We now have 40 organisations that are members to fill gaps in the international legal framework. Since we started, we've had 4 presidents of Angola, Costa Rica, Gabon, and Malawi call for a new international agreement to prevent and combat wildlife trafficking. We had Angola, Peru, and Kenya put forward the first ever resolution to the UN Commission on Crime Prevention and Criminal Justice to look at the gaps in the international framework and explore the possible benefits of a protocol. And over 50% of states said they supported it, or they supported it but would like to see it extended to further crimes that affect the environment. At the 12th meeting of the Conference of the Parties to the UN Convention Against Transnational Organised Crime in a week's time, there is a resolution coming forward by Brazil, Peru, and France, which is going to be on crimes that affect the environment and wanting to set up an international process for exploring whether or not we need additional protocols, a protocol or protocols under the UN Convention Against Transnational Organised Crime to deal with preventing and combating wildlife trafficking. Now, this is a very exciting intersection. Environmental law does not enforce itself. Environmental agencies are not always enforcement agencies. We need the international criminal law fraternity through the international legal framework, the organisations that are set up to combat transnational organised crime, to get into this. So we want to see an international legal instrument on combating and preventing wildlife trafficking as broadly defined, or adding other crimes that affect the environment if that's what states want. Because if we do want to implement these multilateral environmental agreements, we have to enforce them. To enforce them, we need to look to the enforcement bodies and the international criminal law framework. That's where we are, that's what we're doing. And for any of you that want to to join this effort through the Global Initiative to End Wildlife Crime, you're very welcome. Thank you.
Well, the thinning and the loss of species is one of the hallmarks of this era, and wildlife crime enforcement can certainly address that. The melting of the cryosphere is another. I'm not sure that law will change the melting of the cryosphere, but what's happening to the Arctic and the Antarctic is critical to a holistic view of the planet and what environmental law does. We're very pleased to have Marta Sabrido with us to address this question. You can change to here. No, you must move. It doesn't move. No, you move over here.
You can stay there, Nick. I can move. Either way. Yeah.
Sorry.
Thank you. First of all, congratulations to the organizers of this symposium, and thank you very much for the invitation. In the Pax Natura project, my topic is polar regions, Arctic and Antarctic, and for this symposium and this panel, I have chosen Antarctic tourism. I think it is useful to briefly recall the Antarctic regime. Antarctica is the subject of claims by a number of states, but there is an international treaty, the Antarctic Treaty, that freezes these claims. Any state can join the Antarctic Treaty. However, only states that demonstrate an interest in Antarctica by carrying out important scientific research are recognized as consultative parties. Currently, only half of the states parties of the Antarctic Treaty have the status of consultative party. Being a consultative party means having decision-making capacity, voice and vote at the annual meeting, the so-called ATCM. The development of the Antarctic Treaty had been two ways, with two independent agreements and with one protocol. The protocol, usually known as Madrid Protocol, is about environmental protection, and it has a committee that works as an advisory body, but the ATCM is the competent body for the implementation of both the Antarctic Treaty and the Madrid Protocol. What kind of activities are possible in Antarctica? Antarctica is unpopulated. The purpose of freezing the claims was to be able to use it peacefully for scientific research. This was the main purpose, but it did not prohibit other activities. And the reality is that there are different types of activities, especially in recent years. In addition to science and tourism, there are other activities such as, for example, sports competitions, and years ago, even a music concert. All activities have to be authorized. This process is carried out by the national authorities. The binding legal framework is set out in the Antarctic Treaty and in the Madrid Protocol, and these international obligations are implemented by national legislation. In the ATCM, for the time being, only soft law has been elaborated, the so-called resolutions, which are hortatory texts, but they are not legally binding. The ATCM can elaborate binding acts, the so-called measures, but after adoption by the ATCM, approval by all CPs, consultative parties, is necessary. For this reason, although there are 3 measures, we do not take them into account. The first measure, as you can see, has been pending for 20 years. And I just said what we do have are resolutions. If this is the situation, why are we bringing up this issue today? Is there any news? The answer is yes. The reason is that there is a great concern about the tourism and other non-governmental activities. It is a phenomenon whose progressive growth and diversification requires improvement. The current framework is deficient. For years, efforts have been made to systematize and present in a clear manner the current framework, obligations, and soft law. And finally, last year, it was decided to go a step further. By consensus, all the CP decided to initiate a specific process for the development of a comprehensive and consistent framework for Antarctic tourism and other non-governmental activities. The work in the framework of a special working group of the ATCM started this year, and the conclusions were the following. What will be the material scope? It will not be limited to environment. An open list of issues is drawn up, grouped into 6 blocks, but 3 key approaches are already identified: environment, science, and human safety. What will be the forum for discussion? The ATCM at its annual meeting, but also in the form of an intersessional contact group. The goal is to be able to finish the discussions in 2028. 2028 is a reference year, the 50th ATCM, but it is also the year in which the host country of the ATCM will be the Netherlands. The Netherlands is a country that is very committed to the process. It is not coincidence that the president of the special working group is from Netherlands. And what is the objective? The process has just begun. It is starting with ambition, but it has not yet been decided if it will be legally binding. Thank you very much.
Thank you very much, Marta. Now we turn to sustainability, and one of the individuals who is very much responsible for ISIL being here in Madrid is Teresa Perello. Professor Teresa is well known to all of you here at the university, but she also has moved into a position of trying to influence the world through aviation. She is the Vice President for Sustainability at Iberia. And so we got to know each other really through working on the sustainable development and the principles of international law to protect the environment. So it's a great personal honor and privilege to welcome Teresa to the panel.
Thank you, Professor Robinson. It's my pleasure to be here with you. And thank you, Monse, for this opportunity. Thank you all. It's a pleasure to be here, back to the university I belong to. So before I start with what I'm going to talk about is the due diligence for an airline, I just wanted to mention what you just, Professor Scalman, just because perhaps I should have spoken about this, the wildlife trafficking and human slavery prevention, because airlines have a role to play. And in fact, we are very concerned about this, and the international organization that aggregates all the airlines around the world, IATA, of course, complies with all these, and the IAG, where the group to which Iberia belongs to, of course, does as well. But we are very concerned about this because we know there's a problem, and now at the present moment, it's increasing. This problem is increasing, and so just as an anecdote. We are working at Iberia with an NGO, an organization that shows the, how do you say that in English? Los tripulantes de cabina, the stewards, the cabin crew, thank you. The cabin crew, how to understand who might be in danger while in the plane, because they can't do anything. That's a police matter. So they have to look. And and for that, which is very important, we have to give them education and training, and we're doing that. So it's a very interesting thing, and my team is doing this. I'm not involved because I can't do everything, but I just learned that they are progressing quite well, and that things are improving. But I will look at look at that closely next time. So what I'm going to talk about very briefly, it's about the due diligence for companies. So this involves not just the company, but the whole, all the suppliers that are within the company and works with the company. And that's quite a challenge for any company, not just for an airline. But because there's a growing concern for the impact of any company, particularly in Europe, but around the world as well. So we're subject to a very, very stringent regulation, increasing regulation that I'm going to talk about briefly, so that I don't bore you to death. So as I said, there's been a growing trend in the inclusion of human rights and environmental risks-related requirements in business through new regulation in the EU. Indeed, Europe is the leading force in this area with the Corporate Sustainability Reporting Directive, the Corporate Sustainability Due Diligence Directive, which I'm going to talk about right now, and the EU Taxonomy Regulation, among others. But these three are all interconnected. It's not in silos. This is all interconnected. So the Corporate Sustainability Reporting Directive entered into force in January 2023 to establish an obligation for companies, such as Iberia, to submit information on environmental and social issues, as well as a respect for human rights. So this links to the due diligence again. This reporting must ensure consistency with the UN Guiding Principles on Business and Human Rights and the OECD Due Diligence Guidance for Responsible Business Conduct and related sectorial guidelines. A second piece of legislation is the Corporate Sustainability Due Diligence Directive, which will enter into force for big companies such as Iberia. This is more than 5,000 employees and $1.5 million in net turnover in the year 2027. So for now, at the moment, we're not, we don't have to do this, but we have done it. We have gone through a process to understand what is going to be needed, because it's quite complex. It enters into force gradually for, depending on the size of the company, but for us it's the year 2027. This directive adds a new duty to perform due diligence to identify, prevent, mitigate, and account for external harm resulting from adverse human rights and environmental impacts in the company's value chain. And the other piece of regulation interlinked with this too is the taxonomy. On the one hand, the green taxonomy that entered into force in January 2023 and is already making the life difficult of the people in the financial area in the companies, and the social taxonomy, which is still under development. The taxonomy offers a classification system for companies and investors to determine whether an economic activity is green or social when the other taxonomy enters into force in the near future, or not. Therefore, compliance with sustainability standards conditions the financing capacity for companies, which is a critical element for all of them. And this is very happy for me because then they pay attention. When it's money, they pay attention. So at Iberia, we have initiated this process ahead of the European regulation to understand potential issues in our value chain with sufficient time, and thus have the ability to correct them as soon as possible, because as I said, you can imagine, I don't know how many thousands of suppliers we can have. The OECD identifies 6 key steps in the implementation of human rights due diligence to assist companies in identifying and responding to potential negative impacts arising from their activity. So 4 steps on specific activities. First, identification and assessment of stakeholders. First, you have to look for what are the stakeholders. Second, prevention and mitigation of risks, monitorization and communication. Communication last. Some companies like to do it first. That's greenwashing or social washing. And 2, supporting measures, integration of responsible business conduct into policies and management and provisions for cooperation in remediation. So how can a company put this into practice? Through a 4-phase methodology that will help, and this is what we've done already, to help understand the current situation, update related ESG policies within the company, identify the human rights and environmental risks, and define and implement a comprehensive action plan. So first, the revision and update of policy and supply chain characterization that exists at the moment, revision of our policy and procedures. This is very difficult, you have to understand, with a lot of people involved. Some people don't give the data, so it's very, very difficult. It takes time. Conduct a benchmark. We always look at what others are doing and understand what's the best practice at the moment. Not other airlines are doing this at the moment. Elaboration of a supply chain characterization and map classifying the supplier by type, typology, volume, and geography. You have to identify all the suppliers for the sector and geography. Second, identification and prioritization of risks, elaboration of a list, definition of a roadmap to ensure the prevention and mitigation of the risks. Third, definition of an operation and communication action plan. And last, implementation plan with a list of scheduled activities, timing for implementation, and the communication report. And that's what we are at the moment starting to do, but we just have planned this. We haven't conducted everything yet because, and this is another difficulty, we have to do it at the IAG level. So on our side, we've done what we need to do. But now the first step is to send a questionnaire to suppliers and stakeholders, and we have to stop there because this will be done at the IAG level. Thank you.
Well, that's a marvelous tour d'horizon of the issues that a business has to put into place if they want to be part of the sustainable movement that the law now requires. So all of you who are students looking for employment one day, either representing or working with companies, are going to be doing the same thing. It will just be adapted to the type of enterprise that you're involved in. Our next panelists are going to look at ecocide and the whole question of whether the harm that we are doing to the planet has further aspects that need to be addressed in the criminal law context. And so we're very fortunate to have with us Rodrigo Ledo, who is a member of the expert panel on on ecocide, and very much involved, we were speaking earlier today, with the movement to internationalize the acceptance and implementation of ecocide. So the floor is yours.
Thank you very much. Thank you for this wonderful university and for ISIL to organize this symposium and for this opportunity and for the invitation to me. For the other side. Well, I will speak less and I will show a lot of image. So you are young people, you are used to see a lot of image. So I want to this presentation will be in your mind after this. This is a typing point or point of inflection in human history. I hope you recognize those kind of image. Those funny guys, Hitler and the Minister of Propaganda, Goebbels, and the entrance of Auschwitz and so on. So the answer of this typing point was create United Nations, the Nuremberg trial, and Universal Declaration of Human Rights. I hope you recognize this wonderful lady, Eleanor Roosevelt, who was the responsible of the Declaration, Universal Declaration of Human Rights. The original idea was come from her. Well, regarding the Nuremberg trial, it started a very long process, 50 years, to create International Criminal Court. From 1998, we have this institution already created. What is here is another typing point, in my opinion. We are reaching another typing point. Climate change, massive destruction of the environment. So, to avoid the worst scenario, we need to adopt many measures. Measures from different disciplines, science, economics, policies, and so on, and of course, some measures from the law. So here you have some image from some important initiatives. We talk about climate justice, right of nature, sustainable development goals, the environment and human rights, nature restoration law, and so on. So what we do is another approach, what is from international criminal law. You know, international criminal law started with the Nuremberg trial, this 50 years process to adopt the International Criminal Court, and the court processed genocide, crimes against humanity, war crimes, and crimes of aggression. And we are proposed that ecocide will be a fifth crime under the jurisdiction of the International Criminal Court. So ecocide is not a new concept. Ecocide comes from the Vietnam War. This image are the most famous image of this terrible war. So this guy is Arthur Galston. Arthur Galston was the first person that speak in public the word ecocide. The word ecocide. And ecocide is a Greco-Latin word that comes from Greek that say eco could means home, and side in Latin means kill. So literally, ecocide means kill your own home. Well, I have no time here to speak about the evolution of the ecocide concept that from Vietnam War to these days, but these images are a lot of important events in this evolution. One of them, Richard Falk, protocols of Geneva, and so on. Well, this evolution, unfortunately, and in the International Criminal Court, in the Rome Statute, what happened over there is environmental damage is only just a figure, a special figure of war crime. Just only in wartime, we protect, International Criminal Court protect the environment, only in wartime. But that happened over there is that this article 8b24, this article is so restricted. So even the expert suggest that will never be applied. In fact, in practice, has never been applied today, until today. And I attend in a seminar in United Nations last December and talk about a lot of experts about this specific crimes, and if this, and discussion was about if this crime could be applied to the Ukrainian war regarding the Kokokva press. You know, this press that broke up and spread tons of water and killed many people and killed many animals and forests and so on. This is literally an ecocide. But the expert says that it's very difficult that this Article 8b(2)(4) will be applied in this situation. So clearly we need something more to protect by the international criminal law the environment. So what happened that this institution, Stop Ecocide, create an independent expert panel, convene an independent expert panel for the legal definition of ecocide. This is an image of 12 experts, and in this link, you will have the definition and very long commentary regarding this, why we consent about this kind of definition. And this image is about the COVID-19, of course, because in 21 we were in pandemia, and this panel were convened during the pandemia, so it was online work. Well, I have no time to talk about the online work of this wonderful panel, but allowed me to say some few words about the characteristic of this international panel. 12 experts with gender balance, racial and ethnic inclusion, continental representativeness, 5 continents were represented, legal system representativeness, common law and civil law, an expert in international criminal law, environmental law, academics, UN and ICC judges, former ICC prosecutors, and lawyers litigate on domestic and international level, and so on. Well, this panel has 2 Latin America's members. One of them was Pablo Fajardo, who was the famous Ecuadorian lawyer that litigate against Chevron or Tersaco case because the destruction of the Ecuadorian Amazon. And the other one was me. In that time, I worked in the Baltasar Garzón International Foundation. I am from Chile, and I live in Madrid, and I got my PhD from this wonderful university. Well, this is the definition of ecocide. I have no time to talk a lot about this definition, but just allow me to read this. Ecocide means unlawful or wanton acts committed with the knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. So just a general comment of this definition. This definition, it was intended to be applied by the ICC, not by domestic courts. So if you want to transpose this international definition to domestic legislation, you need some adaptations, especially in civil law countries like Spain, like Chile, and many Hispano-American countries. Well, this definition is intended to adopt an ecocentric or biocentric approach, which means that we protect the definition protects the environment, not only when human beings are affected. This definition does not pretend to be neither the only one, nor the first, nor the best measure to protect the environment, nor does it excludes other environmental crimes. It's only intended to be a definition to start the debate in the ICC, in the Assembly of State Party of the ICC. So between 2021 to 2024, between this definition, to nowadays, the campaign has gained support to high-profile endorsement, like Pope Francis or Paul McCartney from the Beatles and many important figures, including a UN General Secretary. And we promote this definition at academic level. So, for example, in this wonderful university and other universities from Latin America's countries and European countries, even in Africa, even in Asia. So what happened during these years? As a side effect, as an externality, is some countries start a process to include the definition of ecocide in their domestic legislations. For example, Belgium has already ecocide in their criminal code. Maite will speak about the European Union directive about environmental crimes, which include an article compared to ecocide. Netherlands is another country that has a bill of ecocide law. Italy is another country in Europe that is thinking to regulate ecocide in their domestic legislation. In Latin America's country, because I am the director of this campaign in Latin America's country, Bolivia has a bill of ecocide law. Mexico, Brazil, Peru, Argentina has a draft of law, not a bill of law already. Chile is a special situation because Chile passed a law of environmental crimes. It's very similar to what happened in European Union directive. They create an article of serious environmental damage. They not called ecocide, but it's very similar. And the last country, Latin America, is Colombia. Colombia has an article in the criminal code, Article 333, it's called ecocide, but the definition of ecocide in this Article 333 is more related to crimes against humanity than the international definition that we propose in the International Expert Panel. So what happened right now? Just last month, September 9, the crime of ecocide was formally proposed to the Assembly, as a new crime under the jurisdiction of International Criminal Court. These three states, Vanuatu, Samoa, and Fiji Island, proposed, they are small island states, the states that are threatened, that will disappear from 10 years, 20 years more in the future. In fact, they already suffer from, they call sea invasion. So during the some month of the year, some part of the islands are under the water, already under the water. So they need to grow, to find places to live in the high part of the islands. This has already happened. So those small island states proposed officially to the International Criminal Court to adopt the crime of ecocide. This is a picture of this special moment. This is Vanuatu representative, and I want to say some few words about what happened with in that time. Vanuatu statements. Vanuatu say that proposal adopt the International Expert Panel definition. The other important thing is Vanuatu consider this definition is an appropriate starting point for consideration of ecocide law by state parties. Another one is ecocide should be an independent crime within the statute. This is very important because it's not to add as a crimes against humanity or as a genocide or as a war crime. Ecocide will be an independent crime and a special crime. More statement, ecocide is necessary because Rome Statute protects people and property, but not environment itself. And the other one is Rome Statute explicitly address environmental harm only during wartime and with an exceptionally high level of high threshold. Well, the last Vanuatu statement could be a crime to protect the environment in peacetime as well as conflict is of fundamental importance, not only to cover the inadequacies of existing law, but also to promote a shift in mindset in both contexts to reflect an understanding of the severity of the danger posed by grave environmental harms. Well, I have no time to say more quotes. I will reach to the end. What happened next? What happened next is that this guy, UN General Secretary, put this amendment in hands of the working group on amendments of the ICC. And this working group has to study the proposal, and finally they need to propose to the Assembly of State Party, and they need to decide that if they took the decision in Assembly of State Parties, general, normal, or in a conference of review. I probably will adopt the second because the importance of this amendment, because you are adding a new crime in the Rome Statute, so it's very important. It's very substantive change. So probably will be a review conference. And probably they choose one of the two possibilities, which is 2/3 of states, which means that we need to get the volunteers, the willing of 83 countries from 124 countries that are member of the Rome Statute. So nowadays we have 3, Vanuatu, Samoa, and Fiji. So we need 80 more. 80 more is a very strong task. Well, and the other thing is that the situation is dynamic, because the elections take place for time to time. So they need to have the special moment to get the willing of those 83 states. Well, final words. The creation of ICC already, I said, that took 50 years. But after war in Yugoslavia, 1981, and after genocide in Rwanda, took only 7 or 4 years. So what happened next is that the situation, the global situation, or the push to the creation of the International Criminal Court. So my reflection is, it depends on us, because we are reaching this tipping point about climate change and destruction of the environment, etc. So it depends on us what time this will take. Probably not only 50 years, because we have no time to do it. Yeah, that's it. Thank you very much.
Well, thank you very much for a tremendously interesting and very exciting prognosis for ecocide. It's not just an idea for academics, it's now at the practical stage. We're very honored and pleased also to have a second presentation on ecocide in the context of the European Union's Environmental Crimes Directive, and Maite Mampo will take us through that. The floor is yours.
Thank you. Thank you to Carlos III University for organizing this symposium, to Montse, and to ISEL as well. And all the topics that have been put on the table today have been really, really interesting in the context of protection of nature and Mother Earth, our planet. So on the 26th of March of 2024, the Council of the European Union formally adopted a new directive on the protection of the environment through criminal law, with the aim of improving both the investigation and the prosecution of environmental crime offenses. The directive establishes European Union-wide minimum rules on the definition of criminal offenses and penalties, and it replaces the former directive which dates back on 2008. The need for the revision of the former directive is obvious. According to Interpol, in just few decades, environmental crime has become the world's fourth largest criminal sector, growing 2 to 3 times faster than the global economy. These crimes are very often linked to organized crime and are at the root of many conflicts around the world, finally contributing to the destruction of living conditions on Earth. And Europe is not an exception of this global situation, as there were many numerous examples of environmental crimes that were unpunished because they were not included in the scope of the former directive. Therefore, the new directive aims to strengthen environmental criminal law in Europe by expanding in its Article 3.2 the list of offenses from 9 to 20, so that it includes 11 more offenses than in the previous law. The new directive has also introduced a qualified offense clause, Article 3.3, which applies when an offense referred to in the directive is committed intentionally and causes the destruction of or irreversible or long-lasting damage to the environment. This new offense is based on the legal definition of ecocide reached by consensus in June of 2021 by the independent panel of experts convened by Stop Ecocide Foundation, the one that has my colleague Rodrigo Lledó has talked about, and he was part of it. And this text, the new directive also specifies that in the case of widespread pollution, forest fire, or major industrial accidents, this offense will be equivalent to that of ecocides as debated at international level. Another relevant improvement in that is that the new directive broadens the definition of conduct considered unlawful to ensure that offenders can be prosecuted even if they had an authorization to carry out their activities, particularly when the authorization was obtained fraudulently or by bribery, extortion, or coercion, but also when the authorization is in clear breach of a substantial legal requirement. The extended definition of unlawful conduct would thus apply both to the list of the 20 offenses in the Article 3.2 and to the qualified offense defined in Article 3.3. It is also important to remark that the inclusion of the qualified offense, which means to recognize ecocide-level crimes, will strongly reinforce existing environmental laws across the region, as it creates both a moral and a legal red line essential for European industry leaders and policymakers going forward. Historically, new crimes have come into being in response to situations of sufficient gravity, extending proscribed behavior and criminal sanctions into new areas. In the 1940s, we saw how the international crimes of genocide and crimes against humanity were born under just such circumstances in the face of the atrocities that just has taken place. Today, in the context of global crisis, of climate change and loss of biodiversity, we face a similar urgency with respect to destruction of natural living worlds upon which we, as a species, along with many millions of other species, completely depend to survive. The European directives are not directly applicable throughout member states, but required national laws to incorporate their rules into national legislation in a process called transposition. In the specific case of this directive, the member states have 2 years to adapt their national rules to the new directive. A key point here is that member states have the possibility of going beyond the minimum definition of crimes set in the European Environmental Crime Directive. This is important when the transposition takes place at national level, especially regards two issues. First, although this law will only apply to offenses committed within the European Union, member states are able to choose to extend their jurisdiction to offenses that have been committed outside their own territories on behalf of a company established on their own territory. And second, but not less relevant, member states have the possibility of introducing a general offense of ecocide to specifically address severe or either widespread or long-term damage to the environment. The establishment of a specific offense of ecocide would cover any act that leads to this result of vast destruction, whatever the activity itself is, instead of being a qualified offense applying only for the activities that have been listed. In this way, the protection of environment would be fulfilled for any new potential destructive activities happening in the future, which are not included in the list. It will depend on each country to improve the new European Environmental Crime Directive and to create a more ambitious legislation. Member states have the opportunity to be at the forefront of this required global transformation of our societies, in which destruction gives way to a relationship of protection of the natural world that sustains us. To introduce ecocide as an independent crime in the national penal codes is the cornerstone for this protection to be effective in all circumstances. EU member states have now the opportunity to become leaders in the implementation of ecocide as an independent crime in the respective legislation, and thus improving the European directive. Thank you very much.
Well, thank you for charting the next couple of years of exciting legislative activity throughout Europe, because I think not just the EU will respond to the directive, but other European states outside the EU will look to see what's happening, so including around the world. We now have the opportunity to have some important commentaries on these exciting presentations and the whole question of law and accountability for protecting the environment. Our first discussant is Professor Montserrat Abed, whom you all know. We're much in her debt and with great gratitude for her work for ISIL and UC3M. We welcome her to the podium.
Thank you very much. Well, congratulations to the speakers. This panel has been very insightful in the exploration of recent developments and on different topics, wildlife, polar regions, environmental crimes, or the role of corporations. Also, it has been really useful to reflect about how the governance of these issues is dependent in a way or another on the evolution of the current geopolitical scenario. How can be possible to bring hope to this world in turmoil? How to ensure sustainability in the increasingly complex, degraded, and dangerous current international landscape? I want to stress the need to include peace as the fourth indispensable pillar within the Sustainable Development Framework. In particular, since the adoption of the Agenda 2030, as UNEP has made clear more and more thanks to its reports on the environmental rule of law. By taking peace as the fourth indispensable element of sustainable development, we'll be able to better grapple as the current planetary crisis should be seen as an integral crisis affecting nature and human rights simultaneously. As David Boyd, the former UN rapporteur on human rights and the environment, used to underscore. With the current sustainability crisis at the global level, or while this crisis cries out for structural transformations, we have to be aware that the necessary political will for bringing any relevant legal change and its better application seems to be more out of reach than ever before, at least since the end of the Second World War. Given this deadlock, it's worth placing emphasis on the potentialities of other actors targeted by Agenda 2030, by the Agenda 2030. And not only states and governmental actors, thus the private sector, which is represented here in this panel, also has the responsibility to pursue the Sustainable Development Goals, including the goal number 16, to pursue peace, justice, and strong institutions. Well, we are aware that corporations are powerful actors in international relations that often behave badly, causing very negative impacts for both nature and human rights, while hide themselves behind complex and non-transparent supply chains. The new corporate sustainability due diligence brings a ray of light in this regard, although its content is still very insufficient, as Teresa has shown very well. In any case, it seems key that companies conduct due diligence to identify, prevent, mitigate, and account for how they address their adverse human rights and environmental impacts, including a standard of reinforced, heightened, or increased due diligence for high-risk areas in these turbulent times. It seems key to advocate for that, knowing that everyone has a role to play. So, thank you.
Thank you very much, Monse. Our next discussant is Professor Joachim Alcaide, who is taking the floor now.
Thank you very much. I would like to highlight, to raise the relationship between the topic of this panel, putting the spotlight beyond geopolitical borders, and the current object of my research in the framework of the Paz Natura project. And I would like, from here on, to express two thoughts that come to my mind related particularly to the presentation of Professor Sobrido on the polar regions. My research is focused on the recourse to the environmental law, the law of protected areas, to complement humanitarian law, the law of armed conflicts, the protection of environment in relation to armed conflicts. Considering the geopolitical borders and beyond, environmental law can complement humanitarian law at least in two ways. First, offering an interpretation or further guidance on the issue of the designation of protected zones in relation to armed conflicts. Environmental law could help, for example, to inform the geographical scope of the designations around, or the designation of the parties to the conflict, including the creation of buffer zones or buffer areas around the protected zones, and the sufficient connectivity between them to ensure species survival. It is important that the states or the other parties to the conflict ensure a sufficient geographical scope for protected zones, including through a network of sites as connected conservation, such that if one area is damaged, the species have access to habitat corridors and so can flee dangers. Buffer areas and interconnectivity of areas even beyond geopolitical borders. The second way is that the complementarity between environmental law and humanitarian law could also benefit from the extraterritorial applicability of environmental law beyond geopolitical borders. Be it, as stated, through the interpretation of environmental law by the state parties to the environmental conventions, or through the object and purpose test as a due diligence obligation. Projecting this complementarity in the polar regions, two thoughts come to my mind. On the one hand, concerning Antarctica. In principle, there is no geopolitical borders there, aside from the well-known territorial claims or the basis of claim, and it seems undisputable that at least since the Madrid Protocol on environmental protection to the Antarctic Treaty entered into force in 1998, the Antarctica is in itself as a whole a natural reserve devoted to peace and science. Then I wonder how it's managed that military activities cannot be carried out there, but many activities are carried out by military. The situation is, on the other hand, very different in the Arctic, or the circumpolar north, crossed by the geopolitical borders of 8 states, included the United States and the Federation of Russia. Yet, it is still a region with a unique environmental relevance when considered as a whole. Then I wonder how the geopolitical borders there might affect the contribution of the declared protected areas to the eventual designation of protected zones in relation to armed conflicts. Thank you very much.
Thank you very much indeed. Our final discussant, Dr. Alvaro Jarillo, a senior lecturer on public international law. No? Oh, it's changed? Thomas Hansen? I'm sorry. We have the wrong list in front of us, sorry.
No problem, no problem. Yeah, thanks to the organizers, ISIL and Pax Natura. What a wonderful day, and so many interesting presentations in this panel. I'm really happy to get the chance to comment a little bit. I will make it brief, and so I'll try to focus on a particular topic near and dear to my heart, namely ecocide, that was addressed in some of the presentations in this panel. So some really exciting developments have occurred over a fairly short time, both at the international level and at the regional level and at the national level. So what I would like to do is to raise 5 points that I think are central to think about when we move forward with our research and advocacy agenda relating to ecocides. So the first is norms adoption. So one crucial question I think we need to think about in that regard is what factors actually determine success both at the international level, but also at the regional and national levels. The second point is about norms dissemination. So how is the ecocide norm actually spreading across jurisdictions? What factors are driving this norms dissemination? So that's something to think about. Thirdly, norms form and symbolism. So to what extent and why is it significant what form that the ecocide norm takes, as an international crime, or as a transnational crime, or as a crime simply under domestic law, or maybe some other form that we haven't even thought about yet. Fourth, norms monopoly, pluralism. So this has been an extensive debate already. Is it helpful to have one singular definition of ecocide, or might we be served well by actually having multiple definitions at this point, and so to speak, try to test these different expressions of the ecocide norm? And lastly, norms complementarity and synergy. So how do we ensure better and more meaningful synergy between the different levels where we see the ecocide norm currently adopted? So that's very brief, and that's just the 5 points I wanted to make. Thank you.
Thank you. Well, thank you very much for those very insightful 5 crisp points for us to critique ecocide. And now, with apologies for jumping ahead of the schedule, our next discussant.
Thank you very much, and well, hello to everyone. Just let me a few seconds to thank to all the partners and University Carlos III for the excellent organization of this symposium, especially to Montse Abad, of course. Well, this brief contribution I'll try not to be very pessimistic, but I think it's necessary to say that we are living difficult times for international law. We are living a very sad time, so I think that it's good to raise a point linking the international law and the security issues. With this approach, I'll try to raise 2 points and to do a brief contribution that I hope that will help to complete the approach of this panel, as the title said, and you mentioned, to go beyond geopolitical borders. My first point is to underline the relationship between security and climate change in the domestic and external policies of the states and international organizations. I'd like to mention a new, well, not very well known concept, but particularly new after the NATO summit in Madrid, which is cooperative security. It's very well known that there is a close cooperation between the European Union and the NATO organization, and this concept, in its original meaning, was defined as an active engagement to enhance international security through partnership with relevant countries and other international organizations. The step forward that was fulfilled at the Madrid summit was that that document, the new strategic concept, introduced formally a new relationship with security and climate change, at least formally. In that sense, that document that I invite the students to read it, reaffirm the necessity of international cooperation to fight against the effects of climate change. Among other commitments, the document said that the alliance will lead efforts to assess the consequences of climate change for defense and security and address those challenges. 2 years ago, some authors and part of the universities began to use the term climatization. It's very difficult to pronounce in English. As we did in the past with other terms like securitization. Since then, there have been some initiatives such as the NATO Climate Change and Security Action Plan, or the climate change and security impact assessment. I think that these actions usually refer to some of the key concepts that we have, and we will continue discussing the next year, such as adaptation and mitigation of the effects of climate change. But concluding this first point, I think that the capabilities of that cooperation between NATO and the EU could be much stronger to fight against climate change, and they have not been fully developed. I'm afraid that the current international security agenda is now facing other priorities. My second point in this same sense is related to the framework of the main bodies of the United Nations. Unfortunately, the Security Council till now has failed to recognize a specific general relationship between climate change and security. It has been mentioned in a lot of resolutions, but still we don't have a specific resolution on that topic. The most relevant attempt to pass this specific resolution took place on September 2021, but the Russian delegation refused to consider the effects of climate change as a global threat to peace that should be formally incorporated on the Council agenda. At least, as Montse Abad mentioned before, there are new steps like the new agenda for peace of the General Assembly that mentioned last year the concept of climate emergency and established different levels of cooperation with regional and international institutions like the IPCC that will be mentioned in the next panels to achieve or to challenge that integrated approaches to climate change, peace and security. In this sense, I invite the students again to read the recent UN Pact for the Future, which is a very long document, very well known, that was approved last week or last month. And that document calls upon urgent action to address climate change and includes a wide variety of topics like such energy security, food security, or climate justice. In summary, with this short contribution, I just wanted to raise the question of how to reinforce cooperation among international organizations when dealing with international security and environmental protection. The current threats to peace that have been mentioned are making difficult these new commitments, but we must be optimists, as you mentioned at the beginning of the day, and continue fighting for justice. Faced to this difficult time, I invite the students, especially the young students, on what we have called at the beginning of the session as the transformative effect of law. Thanks a lot for your attention.
Well, if we had any doubt that law has a transformative role to play before the symposium began, I think the doubt has been erased, and we now see a dynamic engagement of law at all levels to begin to address this crisis we have of the climate and the environment. So I want to thank all of the members of the panel and all of the discussants. It's been a very, very rich set of views, and I would point out that what you've heard today you will not find in very many law review articles or books. These are cutting-edge presentations. You're at the edge of new ideas and new thinking. It's a great privilege to be here and share and listen to each other because you're really moving into the future. So it's been a great afternoon, and I can declare the session closed. And I don't know, Montse, if you have any other announcements we need, or no? Yeah. So we move on to further. Yeah, all right. We stand adjourned from this session.
I'm just